Yes. Supplementary list, old matter, item number 1.
My lord, infructuous, my lord.
All right. This Mr.
Obliged, my lord.
All right.
Item number 2.
Obliged.
Unobvious.
Item number 3.
Unobvious.
My lord, erstwhile employee, Oil Orissa, your lordship, Oil India, which was merged to the company in a company, my lord, had challenged the honorable single judge order in the present appeal, where my application for proportionate pension also was not considered, apart from the fact that I challenged, my lord, this temporary period of service that I had rendered with the company. There is a provision, your lordship, which your lordship, the honorable single judge has also quoted. In order to appreciate the fact, your lordship may have look at annexure 1, page 20 of the appeal. Pursuant to this application, my lord, I was given appointed at Oil India Limited at annexure 2, same basis, that is 5th June 1980. Then your lordship, this company was taken over on 13/10/1981 and it was amalgamated. Oil India came into force by virtue of the operation of law by the Parliament, my lord. Then on pursuant to this appointment, my lord, I had also applied for this, entered into, sorry, my lord, I was enrolled in the Provident Fund scheme and other aspect, and at page 27, permanent employment was given to me at January 13, 1982, with effect from 2nd January 1982, my lord, at page 29. A VRS scheme came into force, my lord, that is begins with this VR application for my VRS. Your lordship, my request for VRS was accepted at page 40. Annexure 9. There they say you will be paragraph 3, you will be eligible for voluntary retirement benefits in addition to your normal entitlement as PF, VHF, VPF, gratuity, etc. as per company rules. Then what has happened, my lord? This temporary period of I challenge because of this. I questioned my acceptance of voluntary retirement before this honorable court, which I lost. I also lost with regards to the period of temporary service which I had rendered before this honorable. That petition also I lost in a division bench of this court. In fact, honorable Supreme Court had earlier also confirmed, or rather has dismissed my SLP with regards to this VRS matter, my lord. Now, in a review, I stated before this honorable court that there, apart from my that period of regularization, there is scope for giving me proportionate pension, my lord. There is this scheme. And if your lordship would look at, single judge has also indicated that.
You're not a regular employee, how will you get paid?
I was a regular employee after that, my lord. I was regularly appointed thereafter. This is my regular appointment, my lord.
No. In your regular appointment, you do not complete the qualifying years of service.
That is why I am bothering your lordship. 20 years had I had completed, I would have been entitled to full pension.
Correct.
But there is a scheme for 15 to 20 years, my lord. Your lordship, I turn to page 53.
Yes.
Clause 12.
Correct.
Former employee. A former employee who is not entitled to normal pension, who is entitled to normal pension, my lord, previous is 20 years of service. Normal pension under these rules shall be entitled to receive a proportionate pension provided as on the date of retirement he had attained the pension age. He had completed less than 20 years but more than 15 years of service. I come under this category. Because from 2nd of January 1980 until 99 August, your lordship, I had completed more than 15, less than 19. Sorry, less than 20. I submitted before your lordship that taking into consideration of this period, I should have been given proportionate income, proportionate. Instead of this, what they had offered me, your lordship, which of course they have not carried out so far, that is at page 43, which I had challenged in the writ petition and appeal as against which, order against which this appeal is pending, my lord. If order 43, your lordship, look at, these were my claims. Few of my claims were allowed, but the effect of that has not been given to me. As regards to pension, that is at paragraph clause 8, Oil Orissa pension is admissible only to those employees who were on permanent rolls of the company on the date of nationalization of the company by Government of India on 14th October 1981. Since you are an employee of permanent rolls of the company only on 2/1/92, you are not eligible for the same. 82. May I pray, your lordship? I will come up with a date chart.
No. We're not adjourning. Just come to, there's a very detailed discussion in page 56.
Page
Actually, you can start with the bottom of page 55.
55. In order to appreciate the rival submission of the parties, this court has perused the original record such and such, and from its perusal, it transpires from the order of appointment dated 13/1/82 that the petitioner was appointed afresh on the basis of application dated 25/4/1980 as telex operator in grade 3 of this clerical program with effect from 2/1/1982, with the condition that the temporary employment shall stand terminated after the close of working hours on 1/1/82. Relevant part of the order of the employments, annexure 2 of the writ petition such and such is being quoted here and below. We refer to your application and to your subsequent interview with us, and we are pleased to offer you employment as a telex operator grade 3 in the clerical program in our organization with effect from 2nd January 82. Please note that your temporary employment with us by our letter dated such and such stands terminated after the close of working hours on 1/1/82. From perusal of the terms and conditions of the offer of appointment, it is evident that the petitioner was appointed in pursuance to an advertisement issued by the opposite party corporation. On being addressed, he was appointed telex operator grade 3, clerical in January 82, with a specific condition that the temporary appointment stand terminated. This temporary appointment was referring to, my lord, that period from 1980 until 1/1/1982. The moment past service have been directed to be terminated, and it was terminated, the petitioner will be ceased to be beneficiary of any benefit of the subsequent employment that will be effect of termination of the past service. In view of such a settled situation, the claim of the petitioner that he has been offered with membership of fund under Burma Oil Indian Company, as the petitioner refers annexure 3, and on the ground he is claiming to come under the provision of condition number 12 of the corporation pension rule, is of no substance, for the reason that even assuming that the petitioner had membership of the fund, but the moment his membership of the fund being in employment under Burma Oil Company in the capacity of temporary employee, and the moment temporary employment has been terminated, the said benefit cannot be said to be carried forward to the subsequent appointment even after acquisition of the Burma Oil Limited, and also for the reason that petitioner has been made a new member after subsequent employment, which also clarifies the position that petitioner cannot derive any benefit from the members under the Burma Oil Company Limited. Here may I submit, my lord, that's number which was there with the Burma Oil, that provident fund number continued.
No, but the fact is that got terminated. See, this is a fresh appointment. There was no carry forward of your provident fund in oil into this. There's a clean break. So one of the essential conditions is not fulfilled. Rule 12, which you read, refers to Rule 11. Just come back to that rule.
Rule 11, your lord.
12.3 says, this is cumulatively you have to fulfill all these conditions. 12.3 says he had otherwise qualified for a normal pension under Rule 11.
Rule 11.
So Rule 11, normal pension, 11.3, you have to be a member of the fund.
Limited staff, my lord, your lordship may look at this. One of the documents that I have next to this for my lordship. Perusal, say, Provident Fund. PF. No, that's the GT. Huh? And this one, it get the date. 13 November 1980. No, not that. Same one. His lordship is asking something else. My lord, I am referring to annexure 6 of a.
Letter dated 16 to 1990.
16 to 1990.
Right.
As per the term, we enclose here such as per the terms of the appointment letter issued to workmen, paragraph 2, my lord.
Yes.
The appointment was for a temporary period and on the expiry of the said with a gap of 4 or 5 days, again a fresh temporary appointment was issued. This practice was continued. It is not that in my case anyway. This practice was continued till they were made permanent. However, as per our records, they have received payment of salary full month even for 4 or 5 days gap also. For the employees who temporary period expired on October 81, before or after 14th October 1981, before or after, my lord, and were issued with a fresh temporary appointment after the gap of 3 5 days, they have been paid for the entire month. For one employee, how is it? It is a reference code.
How is this relevant here, sir?
No, this is not relevant.
Not at all relevant.
Let me come back to your lordship next week.
No, we're not actually. Sorry.
The petitioner appellate before my lord incidentally is a lawyer of this court also.
Good. He has come to the correct profession.
No, he has not come. So your lordship, it will satisfy him. So my lord may keep
No,
it
no, we're
next,
not
next
adjourning.
week, my lord, I'll come back.
No, sir. We're not adjourning. We're not adjourning. And it is factually correct. The challenge in the present appeal is to an order dated 6th April 2016 passed by the London single judge, dismissing writ petition civil 14033 of 2010 filed by the present appellant, in which he had sought for directions to the opposite party Oil India Limited bracket OIL to consider paying the appellant pension and other retirement benefits by taking his period of service to be from 9th June 1980 till 5th August 1999. And further that they should, and further that OIL should be directed to pay him proportionate pension, considering that he had completed more than 15 years and less than 20 years of service with OIL. Paragraph. The aforementioned writ petition was the third round of litigation concerning the petitioner's claims against the OIL. Full stop. First was concerning the appellant having opted for voluntary retirement, and then which resulted in his services being terminated with effect from 5th August 1999. So the appellant apparently changed his mind and wanted to withdraw his having opted for VRS, which was not permitted. Full stop. He then challenged this by filing writ petition civil 12506 of 2000, which was dismissed on 29th April 2002. Full stop. The special leave petition bracket SLP bracket filed against the said decision was also dismissed by the Supreme Court of India on 9 January 2003. Paragraph. As far as the second round of litigation is concerned, this concerned his plea for regularization. Full stop. He filed writ petition civil 9537 of 2003 for directions to the OIL to treat as the period of service between 9th June 1980 and 2nd January 1982 as regular service for the benefit of and for the benefit of voluntary retirement to be provided. Full stop. This was because on 9 June 1980, the appellant had been appointed as a clerk junior clerk cum typist, correct?
Telex operator.
As a junior telex operator. I saw the word junior.
Junior clerk.
Grade 3 of the clerical.
No, clerk cum typist, sir.
That was initial. That
He
was initial.
appointed purely on temporary basis as clerk cum typist on 9 June 1980. And while working as such, applied for the post of telex operator, in which he was selected and appointed on regular basis on 3rd January 1982. Full stop. His initial appointment on 9 June 1980 was under the Burma Oil Company, which was taken over by OIL on 14th October 1981. Full stop. He claimed that he was part of the Burma Oil India Pension Fund. Paragraph. The petitioner's plea for regularization of the above period of service was negatived by this court by dismissal of Writ Petition Civil 9537 of 2003 on 12th November 2009. In other words, this court held that the period of service rendered by the appellant between 9th June 1980 and 2nd January 1982 was purely temporary and ad hoc. Therefore, he was not entitled for regularization for this period. Paragraph. The third round of litigation saw the petitioner file Writ Petition Civil 1403/2010 in this court, praying for the reliefs as noticed here and before. Full stop. The learned single judge, while considering the plea for proportionate pension, referred to clauses 11 and 12 of the Oil India Pension Fund, which read as under, take from page 52 and 53, the whole provisions. Paragraph. As noticed by the learned single judge, for the purposes of proportionate pension, certain conditions in Rule 12 had to be cumulatively fulfilled. Full stop. While appellant fulfilled the condition in Rule 12 bracket 1 and 12 bracket 2, he did not fulfill the condition under Rule 12 bracket 3, namely that he was otherwise qualified for a normal pension under Rule 11. Full stop. In order to qualify for normal pension, in terms of Rule 11 bracket 3 of the Oil India Pension Fund, he had to be a member of the of both the Burma Oil India Provident Fund as well as the Oil India Limited Employees Provident Fund continuously for not less than 10 years. Full stop. Here, the learned single judge found that there was a clean break in his employment, and he was not given the benefit of carrying forward his membership of the Burma Oil Provident Fund, Burma Oil -India Provident Fund, since his appointment in the OIL as telex operator in grade 3 with effect from 2nd January 1982 was a fresh appointment. Full stop. The terms and conditions of appointment itself made it clear that the erstwhile temporary appointment stood terminated on 1st January 1982. Full stop. This court has heard the submissions of Mr. Sahil, senior counsel, appearing for the appellant, and Mr. Debraj Manthi, learned counsel, appearing for the OIL, and has also considered the impugned judgment of the learned single judge in some detail. Paragraph. Also, although it was sought to be contended by Mr. Sarangi that the appellant's case for proportionate pension ought to have been considered by the learned single judge by taking into account his membership of the Burma Oil (India) Provident Fund, the fact remains that the appointment on temporary basis with Burma Oil between 9 June 1980 and 1st January 1982 was purely temporary and ad hoc, and was not carried forward when the appellant got appointed in OIL with effect from 2nd January 1982. Stop. In other words, it was a clean break, and the appointment under OIL with effect from 2nd January 1982 was a fresh appointment. Full stop. Under the VR scheme, under the VRS, there was no condition of proportionate pension. Stop. The attempt by the appellant to withdraw from the VRS having also failed, there was no occasion for his plea proportionate pension under the Oil India Pension Fund rules to be considered. Paragraph. In that view of the matter, the court is unable to find any error having been committed by the learned single judge in declining the reliefs prayed for by the appellant. There is no merit in the present appeal and is dismissed as such.
In Annexure 12, my lord, they had granted certain benefits which have not been released so far because of the pendency.
If there are any benefits to which the appellant is entitled to and have not yet been released so far to him on account of pendency of the present appeal, that should be released him without any further delay, and in any event not later than 4 weeks from today. Correct.
Supplementary list item number 4.
May I believe in our sin and with the appellant. I have challenged the under Annexure 4 or the single judge.
What's the delay explanation, sir?
Annexure 4 running pages also kindly pays challenge. Prior to that, the Honorable Single Judge also, while deciding other 2 matters, have rejected, dismissed the writ petition, saying that this court case is not maintainable. As at Annexure 2, your lordship kindly find.
Sir, are you able to hear me?
Yes.
Can you explain the delay in filing the writ appeal, sir?
Because after disposal of this application, another senior advocate, Mr. P.K. Padi, who was bedridden and thereafter died, he could not give any instruction regarding the case of the matter.
Let's come to your application, sir. What you have written in your application. Let us see that.
Yes. My prayer is, your lordship, Is it appropriate that Honorable Court be necessary please to admit this appeal, call for the records of WPC number 517.
Kindly listen to me, sir. Am I audible to you?
Yes.
I'm asking you to explain the delay in filing the writ appeal, sir,
Yes, my lord.
for which you have to come to your application for condonation of delay.
Yes.
Please come to that application.
Because this.
Kindly take the page where your application is.
Yes. My
Please,
IA is.
please read para 2 of that application, sir.
Yes, my lord. That the petitioner could not able to file the aforesaid writ appeal due to want of relevant documents in as much as the predecessor of this present petitioner has in the meantime retired since 30th
What is the
2007.
predecessor of the petitioner? What is the
Which is
predecessor of the petitioner? Who's the predecessor of the petitioner?
Orissa State Cooperative representative through his secretary. That secretary was in charge by that time he was retired.
So what?
And the president in command who has filed this application, he was remaining in charge of.
This is not a satisfactory explanation at all, sir.
Thereafter, your lordship kindly find, since this is a case, I pray your lordship, because the Lawrence single judge also, prior to that, in the similar nature of cases filed by the cooperative union against cooperative, that has been dismissed due to want of maintainability. And Annex 2 and 3, your lordship kindly, thereafter also, there is another case also, this same single judge also technically dismissed the petition, filed by the petitioners and the other petition against the cooperative union. This is also an order after filing of this present appeal. The lordship kindly peruse this same order stating that this, since it is a cooperative union, is a society registered under the Society Cooperative Society Act, the remedies are available under section 16B, 67B of the Cooperative Act, either available before the RCS or the cooperative tribunal. In that regard, the 3 writ petitions have been dismissed due to want of maintainability. That is, writ petition is not maintainable before lordship under Article 226.
Have you complied with the impugned order or you have not?
My lord, this order, the impugned order has been passed. We could not comply because of all the predicaments available.
Sorry?
Because the petitioner appellant would not able to comply with the orders of the Honorable Court, stating that in the previous occasion also, when I appeared on this, that has not been.
I'm sorry, sir. I'm not able to understand what you're trying to say. My question to you was, has the order of the single judge been complied with? Because there is no stay granted by this court. Have you complied with the single judge's order?
Because we have challenged the single judge order before lordship.
So there is automatic stay. Is that the rule?
No, that is not. That is not.
That is not. No.
That is not.
Then why have you not implemented?
Because on earlier occasion, 2 separate writ petitions before the same single judge also dismissed the writ application.
No. So you have yourself given yourself a stay.
No, my lord.
Yes.
That is not my case, your lordship.
No. Then how come you have not implemented?
No, because we challenged before lordship.
No, mere challenge is enough. You don't have to get a stay order.
No, my lord. That is not also intention of
everything. You agree with me on everything, but you still do not know. You're not able to explain why you did not comply with the impugned order.
Because of the fact that we have a preferred writ appeal before the lordship.
According to you, the law is if you file a writ appeal, you do not have to implement. Whether you get a stay or not does not matter. The mere fact that you filed a writ appeal means you do not have to implement. Is that the law?
No, madam. Because that several writ petitions against the cooperative union.
How come you did not file a contempt, is it?
Madam?
You also did not file a contempt. Anyway. Yes. What is there on merits? Nothing is there on merits, sir.
Your page 65 honorable single judge has clearly given findings, my lord.
Correct.
Page 65. On the basis.
Complete violation of natural justice. This compulsory retirement could not stand.
He has been retired, compulsory retirement because of the negligence in duty. Negligence.
Without giving him time for even. Yes. You see, there's a delay of 105 days in filing this writ appeal. The explanation offered in Miss Case number 666 of 2017 in para 2 reads as under. Take from page 73, para 2. Paragraph, the court is unable to be satisfied about the reasonableness of the above explanation. Full stop. it does not appear to be valid or bona fide. Full stop. Consequently, the court is not inclined to condone the delay in filing. Paragraph. Nevertheless, the appeal has also been examined on merits. Full stop. The prayer, the writ petition filed by the respondent before the learned single judge was for a direction to the present appellant to release payments of full salary and allowances to the respondent in the revised scale of pay from November 2000 till the date of filing the writ petition, less a period of 7 months between April and October 2000. Stop. Challenge also was to an order dated 28 February 2004, issued by the present appellant, compulsorily retiring the respondent from service and to give him all consequential benefits. Paragraph. It appears that none appeared on behalf of the present appellant before the learned single judge, despite a passover. Full stop. As regards the order of compulsory retirement, the learned single judge noted that while rendering service as district cooperative instructor at Bhavani Patna, the respondent had submitted returns and reports. Full stop. Without considering those reports and without complying with the principles of natural justice, the order of compulsory retirement had been passed. Full stop. In that view of the matter, the said order of compulsory retirement was set aside by the learned single judge. Paragraph. As regards rendering of service, the learned single judge found that it was an admitted position that the respondent was on duty from 24th February 2000 to 24th August 2004, as was evidenced by the documents and letters issued by the Secretary, Bhavani Patna Central Cooperative Bank. Full stop. As far as the earlier period is concerned, an order had been passed on 25th October 2002 for payment of the withheld amounts to the respondent, which had somehow not been complied with by the appellant. Paragraph. In the above circumstances, the learned single judge allowed the prayers in the writ petition. Paragraph. Having heard learned counsel for the appellant as well as the respondent, and having perused the order of single judge, the court is unable to find any legal error having been committed by the learned single judge in granting the reliefs as prayed for by the respondent. Full stop. Factually, there was material before the learned single judge to substantiate the plea of the respondent as regards the order of compulsory retirement being in violation of the principles of natural justice, and for there being justification on part of the appellant for not releasing payments for the period of service rendered by the respondent as prayed for by him. Paragraph. Court is unable to therefore to find any reason to interfere with the impugned order of the learned single judge even on merits. paragraph. The writ appeal is accordingly dismissed, both on the grounds of delay as well as on merits.
Supplemental list item number 5.
My lord, in item number 5 for compliance of the last order, I need a single adjournment for weeks.
This is that reserve forest.
Minutes.
Chendupada.
Minutes.
For constitution of committee.
Mr. Devkant, the monthly and additional government advocate, seeks more time to file an affidavit in terms of the order dated 22nd August 2022. Full stop. Said affidavit now be filed positively on or before 3rd January 2023.
May I, minutes, my out of minutes, turn of the court minutes, my personal problem. If my should accommodate me today because I have to go for treatment of my mother. Another item number 69. Of course,
That will adjourn, sir. No problem.
with due humility minutes, I'm submitting 69. IT matter, I requested my friend, my senior friend.
February. And item 69, who's the other side?
Non-senior is there for Japan.
All right.
Keep it date.
At the request of Mr. Mahapatra, was in some difficulty today. List on same day.
Item number 6.
My Lordship, I'm appearing on behalf of Mr. Pal. My Lordship, this is a trade certificate matter. Similar matters were adjourned to 5th December.
All right. List on 5th December. All right.
Grateful, my Lordship.
Item number 7. Item number 7.
None appears.
Item number 8.
None appears.
Item number 9.
Though there is inordinate delay, but we have got merit in the case.
So we leave the question open, sir.
9,000 days.
There's a new record. There's a not a delay of
9511.
9511 days in filing the present appeal. Is not satisfied with the explanation offered for the inordinate delay and accordingly is not inclined to own it. Nevertheless, the question of law raised by the appellant as arising from the impugned order of the learned single judge is left open for decision in some other appropriate case. The writ appeal is accordingly dismissed.
Item number 10.
My lord, items number 10, we have for the appellant, my lord, Union of India. Can it be day after tomorrow, my lord?
Why?
This part of the record I have received, part of I have not received. That's why
What
I
is
asked
that?
the official, they will come today or day after tomorrow. Day after tomorrow.
Let's see what it is about.
My lord,
Let us see what the matter is about, sir. Even last time it was
it
dismissed
is
for
a order of
non-prosecution.
honorable single judge, or it
It
can
was
be
already
after
dismissed
launch.
for non-prosecution last time.
Can you
Then because you said that you had some problem with the link, that's why we restored it.
Yes, my lord. My lord, can it be after lunch?
All right. After lunch.
Oblige, man.
Item number 11.
Please, may I please let's.
Delay.
My lord, in between the financial benefits has been granted, my lord.
All right. Counsel, the appellant states that the impugned order has already been complied with and that the writ appeal has become infructuous. It is disposed of as such. All right.
Item number 12.
None appears dismissed.
Item number 13.
May I please let's. I had appeared, my lord. My lord, in item 11, my lord, I appeared, my lord.
Yes, yes.
Item number 13.
May I please, Lords?
Yes, please.
The appellant's number 1 husband, while working in opposite party bank, my lord, challenging the dismissal order from service, which were dismissed for non-prosecution. And the husband expert and
His advocate also expired. I filed a petition for delay, condemnation of delay, being the legal heir, and also restoration of the writ petition, which was dismissed, my lord.
What is the explanation given, sir? Let's see that.
My lord, the lordship kindly see the impugned judgment. Page 18.
Yes. 559 days.
My lord. Husband, my lord, appellant once husband expert and also his advocate expert could not appear. The appellant could not hour about the in the case cited by the honorable single judge is not applicable and distinguishable. And in the facts of the present case, my lord.
When did the lawyer die? You have a date of the death of lawyer.
2017, my lord.
Well, I filed a counter affidavit and for the bank opposite parties, I have stated by short counter that the delinquent employee did. The writ is of year 2002. Now it takes the plea of he is totally lacking in diligence in all aspects. Therefore, the CMAPL and
No,
the
this is the
petition.
wife, sir.
Yes.
How will the wife know what petition the husband had filed?
When his husband died in 14, he must be knowing that
How?
there's a case, a service dispute raised by her husband.
No, how? That's the point.
That one cannot, that no one can unveil. Lordship knows very well that we have all
Let it be-
sympathies for delinquent. But he had rode totally without diligence.
Sorry?
In 14 he died. There are takes a plea of 17 died. In 19, the CMAPL was dismissed and the IA was also dismissed for delay consideration.
Correct.
And accordingly, and that decision cited by your honorable single judge is applicable.
Say every
And
case
also-
turns on its own facts.
and
There it is
also
706
University
days,
sector.
here it's some 559 days.
Well, also, the service dispute does not survive in view of the death of the
How?
employee.
Because he gets benefits. Suppose his termination was held to be wrong, he's entitled to back wages for that period, and the family will get it.
Yes. See, we are all sympathetic, but I leave to your lordship
Good.
to totally.
All right. Then that is
But
fine.
with sufficient costs, because it's a case legal for
You're a bank,
2002.
sir. If you are an individual, you would have unique costs. A bank means you should pay.
Bank will pay me, my fees, which is
Your
not that.
fees, the bank will pay you, sir.
No,
You
sir.
should thank him that you got this brief.
No.
That's how you're.
Yes. That is gratuitous. Not due to any effort. But this is so in all cases where the management is pitted
Yes.
against a punishment order.
This is a widow, sir. You should be more simple.
However, as an example, he should pay some costs.
No.
That is my submission.
All right.
If your lordships can bestow compassion on her and her son, I want to come into
All right.
because there's service
The
dispute
challenge in the present appeal
without
not
academic
dated
concession.
27th August 2019, passed by the single judge. Dismissing APL 146 of 2019, filed by the present appellant, questioning the order by which OGC number 4969 of 2002, filed by the husband of the present appellant, was dismissed by the learned single judge for default on 6 July 2017. Paragraph. The background facts are that the aforementioned OGC number 4969 of 2002 was filed by the husband of the present appellants. Appellant number one and father of appellant number 2 against the United Commercial Bank, bracket respond number 1,
Now it is
questioning the order passed by the bank terminating his services. Paragraph. During the pendency of the writ petition, the husband of appellant number 1 expired on 1st June 2014. As it further transpired, even the lawyer who was conducted on behalf of the husband of appellant number 1 himself expired. As a reason, the appellants were not aware of either the pendency of the aforementioned OGC number 4969 of 2002 or of its dismissal for default on 6 July 2017. Paragraph. The learned single judge has not accepted the above explanation by referring to another order passed by the learned single judge in State of Orissa versus Srimati Vishnupriya 118 bracket 2014 CLT 588, where the single judge had declined to condone a delay of 706 days in preferring the appeal. Paragraph. As is evident, the aforementioned decision was in an appeal filed by the state of Orissa and not by an individual. Full stop. Ultimately, every case has to be examined on its own peculiar facts, particularly on the issue of delay. Full stop. No parallel can be drawn between an appeal filed by the state of Orissa with an appeal filed by an individual. Full stop. Consequently, the court is of the view that the said judgment could not have constituted a precedent as far as the present case was concerned. Paragraph. The fact remains that the appellants were the legal representatives of the deceased employee, and there was the explanation offered by them, but the view of the death of the lawyer himself, was a plausible one and merited acceptance. Stop. The rigid rules governing delays caused by the state in filing matters before the court cannot apply ipso facto to appeals filed by individuals, appeals and petitions filed by individuals. Paragraph. Consequently, the court is of the view that in the peculiar facts and circumstances explained above, the delay of 559 days in the present appellants preferring the application for restoration of the writ petition ought to have been condoned. Paragraph. For the aforementioned reasons, the impugned order dated 27th August 2019, passed with the learned single judge, is hereby set aside. This will mean that IA number 189 of 2019 for condoning the delay in filing CM APL number 146 of 2019 is hereby allowed. Full stop. For the same reasons, CM APL 146 of 2019 would also be considered to be allowed. The net result is that OJC number 4969 of 2002 would stand restored to the file of the learned single judge in the roster bench and will be listed there for directions on 15th December 2022. So since the pleadings are already complete.
No, the whole problem is after reshuffling of the zones under the policy of the government of India, this will transfer to Sambalpur zone. It was in the Bhubaneswar zone. So let my learned friend send me give me a copy of the petition. I will send it for paramount comment.
All right.
Some
copy
time
of the petition be served on learned counsel appearing for the bank. Full stop. But you should know pleadings complete in the writ petition.
Well, counter, I have not received the copy.
All right.
Because the Union Government has stated that
Previous counsel is there, my lord, he expired.
Just they then. Other the only comment. Kindly record my counter affidavit submissions, just a para or 2 to 3 lines. Well, I will be misunderstood by the bank.
The
board counter টা দিয়েছি
If not already filed, the bank will file its reply to the writ petition. Will file reply to the writ petition on or before 9th December
9th December
2022,
কপিটা দিয়ে দাও
and rejoinder that if any should be filed by 15 December 2022. Considering that this is an old writ petition, no further time would be granted for that purpose. In the writ petition, the present appellants will stand automatically substituted as LRs of the writ petitioner, and there need not be any separate proceeding for that purpose. Paragraph, the learned single judge is requested to proceed with the writ petition on merits and endeavor to dispose it off as expeditiously as possible, and in any event, not later than 6 months thereafter. The reticle is disposed of in their own terms.
Kindly, I will record my submissions in the writ appeal that I filed a counter affidavit and stated that the lack of diligence and other parts or they are not non-entitlement to the benefits. So kindly record. Unless I'll be misunderstood grossly.
Item number 14.
Yes.
Item 14.
None appears dismissed.
Item number 15.
16, not pressed, my 15.
Appeal counts to the appellate states. Not
15.
It's 16, my lordship. It's somebody 15 and there, your lordship.
15 you're there.
Yes, your lordship. May I please, your lordship?
Yes.
In item 15, your lordship, there's a delay in filing the appeal of 120 days.
139 days.
Yes, your lordship, to be precise.
The delay of 139 days is not properly explained.
No, my lordship, may kindly hear me for a moment. At least this is the matter on merit. What has happened, your lordship, is these appellants, they are class 3 and 4 employees working as peon and clerks in the Acharya Harihar Cancer Institute, your lordship. Now they have prayed with the honorable single judge with regard to the regularization. Now, even the director has sent a proposal to regularize them. Now, I should kindly see the order of honorable single judge, your lordship. Annexure 9, page 40. If I shall permit, I'll just place the order, your lordship. At page 40. 43 is the operative portion. The petitioners have filed this application seeking for direction to regularize the services of the petitioners in terms of Group ND Contractual Employment 2013 and extend all financial and service benefit to the petitioners. In course of hearing, learned counsel for the petitioners state that recommendation has been made by the OP number 2 to OP number 1 for enhancement of remuneration of 16 numbers of employees on 13/2018 in Action 7, which is pending for approval. Considering the limited grievance of the petitioners, without expressing any opinion on the merits of the case, this court disposes of the petition, directing OP number 1 to take a decision on the basis of the recommendation made by the OP number 2 on 13/2018 under Action 7 and pass appropriate order. I should kindly for a moment look at page 37. What is that order? 13/2018. Page 37, your lordship. It is a letter issued by director, Acharya Harihar Regional Cancer Center, to the Additional Secretary to Government, Health and Family Welfare Department. Now, on the next page, your lordship, page 38, the penultimate portion. Therefore, I am to request you to approve the revised order of remuneration to the contractual employees, as they have already rendered minimum 7 years, maximum 21 years of service in AHRCC, and there is no way they can be absorbed as regular staff in HSCC. So they have already taken a decision, but this has been ignored by the honorable single judge. They have already taken a decision to not regularize them, your lordship.
Yeah. So what's your plea for regularization? On what basis are you seeking regularization?
My lordship, kindly say Annexure 1. In Annexure 1, in the year 2002, your lordship, by following all the recruitment rules, we have been appointed on contractual basis.
Correct.
Now, in the meantime, at Annexure 4, the director himself has decided to regularize us. I'll show you, lordship, at page 23, your lordship. Annexure 4, page 20.
All of you are still working?
Yes, your lordship. Now, my only contention is, my lordship, when they have already
consider the regularization plea. It appears that there were two. You say for the reason stated, the delay is controlled. Then in the main writ petition, main writ appeal, you say this writ appeal is directed against an order dated 11th April 2019 passed by the learned single judge, disposing of writ petition civil 5290 of 2019 filed with the present appellants, in which there were two reliefs prayed for. One was for a direction to the opposite party, that is Acharya Harihar Regional Cancer Center, Cuttack, bracket response number 2, bracket, to regularize the services of the appellants who were appointed in Group C and Group D on contractual basis. Full stop. The other was for extension of financial and service benefits to the appellants. Paragraph. It appears that the learned single judge in the impugn order has with only one portion of the prayed for, namely the prayer of the present appellants for enhancement of their remuneration on the basis of a recommendation already made on 13 March 2018 in that behalf by the director of the institute to the additional secretary to the government of Orissa Health and Family Welfare Department. Paragraph. However, what was perhaps not noticed by the learned single judge was that in the same letter, the institute, respondent to institute, decided not to regularize the services of the appellants by observing that it was not feasible
At page 30, dear Lordship.
No, by observing that open quotation, there is no way they can be absorbed as a regular staff in AHROC, Cuttack, unquote. CC, all right, Cuttack, paragraph. The learned counsel for the appellant is right in contending that the aforementioned prayer of the appellants was therefore not considered at all by the learned single judge on merits. Paragraph. In that view of the matter, the impugn order dated 11th April 2019 of the learned single judge is interfered with only to the extent it is not considered the prayer of the present appellant for regularization of their services. Full stop. Writ petition civil 5290 of 2019 is therefore restored to the file of the learned single judge in the roster bench, where it will be listed for directions on 4th January 2023. Full stop. The writ petition will proceed before the learned single judge only to consider the prayer of the present appellants concerning regularization of their services. So the court notes that the pleadings of this aspect are not yet complete. The learned single judge will therefore proceed with the writ petition after ensuring that pleadings are complete and endeavor to dispose of the writ petition as expeditiously as possible. The writ appeal is disposed of in the above terms.
I'm grateful, Your Lordship.
Item note 16.
Infructuous, man. Infructuous.
Counsel the appellant states that the appeal has been rendered infructuous. It is disposed of as such.
Item note 17.
Let's turn to page 90, the impugn order. Relying the judgment of Parlak Mishra case, that matter has been disposed of. That matter has been stayed before the Honorable Apex Court, and I have given my Lord's orders in a similar case. Your Lordship issued notice.
When is it coming up?
Yeah, I have given that order, next order that I have given, that date was not fixed. The lordship was fixed to after 12 weeks. The subsequent order I have given.
But here you've not even taken steps for continuation of delay, sir.
For 28 days. I'll file a limitation. 28 days.
You better clear the defects then.
Yes, ma'am. The lords may call this matter.
Defects be removed within 2 weeks list thereafter.
Ma'am.
Item number 18.
Item 18, may I plead, Lords? My Lord, I am challenging the order dated 7/11/2019, passed in WP number 208/00/2019. What happened in this case, my Lord? The petitioner prayer for cancellation of the registration of the boss, my Lord. Your Lordship kindly see page 18. The petitioner applied before the authority for cancellation of the registration of the boss, as the boss was total unsafe to ply and total damage, my Lord. And after inspection, your Lordship kindly see the last portion, the vehicle so replaced by another vehicle, AP number so my Lord. They have, my Lord, found that my vehicle was damaged, and for which, my Lord, they have replaced. Your Lordship thereafter kindly see Annexure 19, because it is interstate vehicle, my Lord. This the opposite party, my Lord, wrote a letter to the Transport Commissioner come chairman, my Lord, there, my Lord, to the state of Andhra Pradesh, my Lord, for countersign, my Lord, and after replacement. That was, my Lord. Thereafter, my Lord, your Lordship, Annexure 4, my Lord, immediately I have applied the authority for condemnation and cancellation of the registration of the vehicle, my Lord. I have not done so, my Lord. I have approached this honorable court and...
How can you sell it without getting your registration done, first of all?
My Lord?
How come you sold the vehicle?
My Lord, it was total damage. I have not
sold. Selling the vehicle, how can you seek this relief?
It is, my Lord, given to the scrap dealer, my Lord, because it is total damage.
No, but then you can't ask for the relief of...
My Lord, I have approached in the previous writ petition, I have approached, my Lord, this honorable court. This honorable court, your Lordship also kindly see section 55 of the Act, my Lord, for a moment, my Lord. There is, my Lord, no where it is mentioned for production of vehicle for... because it was earlier they have inspected and found that the vehicle was damaged, my Lord. But your Lordship kindly see cancellation of registration if a motor vehicle has been destroyed or has been rendered permanently incapable of use. The owner shall, within 14 days or as soon as may be, report to the fact to the registering authority within whose jurisdiction he has the resident or place of business where the vehicle is normally kept, as the case may be, and shall forward to the authority the certificate of registration of the vehicle. Immediately, I have approached the authority for with a prayer to cancel, but they have not done so. I have approached twice, my Lord, before this honorable court. As per a direction of the honorable court, they have also not done so. In the in the second writ petition, they have directed me to produce the vehicle. My Lord, I have specifically mentioned there, my Lord, since the vehicle is not there, and I have, my Lord, sold the scrap, my Lord. So only the scrap is there, my Lord.
Will you permit us to ask a question, or we should not ask any question? Without waiting for the response department, you went ahead and sold the vehicle, correct? So now, how can you persuade them to cancel the registration then?
My Lord,
there's no vehicle.
My Lord,
you have to produce the vehicle only. Then
I admit, your Lordship, kindly see.
You're asking for cancellation on the basis that the vehicle has got damaged irreparably, correct?
My Lord.
Without producing the vehicle, how will they cancel the registration?
My Lord, since 2016, my Lord, the authority know that the vehicle has been destroyed. And since 2016...
how do they know? Unless you produce...
My Lord, because of that, they have replaced, my Lord. As per Annexure 2. Because they have known that my vehicle has been damaged, my Lord, they have replaced, my Lord. Your Lordship, kindly see Annexure 2.
Yes.
Your Lordship, Annexure 2, page 18. Page 18, my Lord. Your Lordship, kindly see.
Yes.
The vehicle number so-and-so replaced by another vehicle in the bottom, my Lord. AP number so-and-so having so-and-so, my Lord. They have replaced in the year 2016. I have immediately wrote, my Lord.
I don't know what replacement means. I mean, then if it's replaced, then where's the question of asking for cancellation of registration?
Your Lordship,
if you're happy with this replacement, there's no need for you to ask for registration then.
No, my Lord, because
you can't say both things, sir. You still want cancellation of registration of that earlier vehicle, right?
My vehicle, my Lord. My vehicle, my Lord.
So without producing that vehicle which is damaged, how do you expect registration of that vehicle to be cancelled? That's
Your
the only
Lordship,
question.
my respectful submission before Your Lordship is that since 2016, my Lord, I approached the authority
Correct.
that my vehicle has been damaged
Correct.
and it is not safe to fly, my Lord.
Right.
For which they have inspected and found that it is unsafe, for which they have replaced with another vehicle. My vehicle has been replaced.
I don't know, but they don't replace your vehicle, sir. You probably buy another vehicle. No transport. Suppose I take my damaged car, they'll give me another car. The transport department.
On my application, my Lord, because it is a block.
Even if you apply, sir, suppose
Yes,
your vehicle is damaged, you apply to the transport department,
Yes,
they'll supply you with another car. What are you trying to say?
The replacement is different. The vehicle covered under a permit can be replaced by another vehicle.
But the part of the
The
opposite.
vehicle has to be bought by the other person whose vehicle is damaged, sir.
Yes,
Transport
here-
department is not going to buy and give you a vehicle.
Here the
But
after-
since 2016, my Lord, I have pursued my matter. They have not done so.
One fine day, you came fed up and you decided to go ahead and sell your vehicle without waiting for cancellation of registration. You took the risk of doing that.
Since 2018, I sold the vehicle. my Lord,
So you
because-
did not wait.
because the
I'm just
public
saying
may-
2 years you waited.
Yes, ma'am.
No response from the department.
My Lord.
You went ahead and sold the vehicle. That's a risk you took. Now to insist, no, I will sell the vehicle, but still you should cancel my certificate is not
Your Lordship,
permissible.
what I understood in section 55 of the Act, Your Lordship kindly see.
Sir, if you understood it so well, don't ask for these reliefs. You're very happy. You're not waiting for cancellation registration. You're saying, I will go ahead and sell the vehicle, whether they cancel or not. That's a risk
In
you're taking.
2018, they took, they directed me to deposit 500. I have deposited. Your Lordship received it there. But also they do not do anything, my Lord. That's why, my Lord, without finding any other way, my Lord, since
You've done it, then just stay. Don't come to a court and say, no, ask them to cancel and all that. You've anyway not waited for all that. You've gone ahead and done
section
it.
55 is, my Lord, there is no, my Lord, direction to produce the vehicle. My Lord, Your Lordship kindly have.
How are you going to search? Because you say, my vehicle is damaged, now cancel it without even seeing the vehicle, they're supposed to cancel the registration. It's impractical.
55 provides for inspection. After due satisfaction of the authority, then the registration shall be cancelled.
Correct. Yes. See, the challenge the present writ appeal is to an order dated 7th November 2019, passed by the learned single judge, dismissing the petition civil 20800 of 2009, filed by the present appellant, seeking a direction to the opposite party registering authority cum regional transport officer to cancel the registration of a vehicle cancel registration of a bus belonging to the appellant, which according to the appellant was damaged beyond repair in an accident. Paragraph. According to the appellant, he had been approaching the RTO since 29 June 2016 for cancellation of the registration by pointing out that the vehicle was not safe to be plied as it was in a severely damaged condition. Stop. However, according to the appellant, the RTO remained silent for more than 2 years. Stop. In the meanwhile, the appellant decided not to wait for the cancellation of registration to take place and took the risk of selling the vehicle to a scrap dealer. Paragraph. It is in the above circumstances that he had filed writ petition civil 20800 of 2019 for the aforementioned directions. Paragraph. The learned single judge has in the impugned order noted that unless the appellant was in a position to produce the vehicle that was, he could not expect the RTO to proceed to cancel the registration of such vehicle. Paragraph. Counsel for the appellant, while not disputing that he had already sold the vehicle to scrap dealer, submitted that he had waited for more than 2 years for the RTO to respond. And in those circumstances, decided to not wait any longer and went ahead and sold the damaged vehicle to a scrap dealer. Paragraph, with the appellant having taken the risk of selling the damaged vehicle to a scrap dealer, waiting for cancellation of registration, he cannot expect a direction to the RTO to nevertheless issue him a cancellation of registration, even without inspecting the vehicle claimed to have been damaged. Full stop. Consequently, the court is unable to find any error having been committed by the learned civil judge, which calls for interference. The writ appeal is dismissed.
Supplementary list item 19.
None appears dismissed.
My lord, I'm not acquainted at this moment, so I need more time to study because it is being listed. My lord, it is after 11 years it has been listed. So I have to go with the file 54 days only.
We'll pass it over, sir. It's okay. We'll pass it over. We'll call it out. Better we get ready. Okay. Right.
Item number 20.
None appears dismissed.
Item 21.
Yeah, please, my lord. Here the petitioner was contractor made tender application before implementation of GST Act and executed work after GST. And as per Annex 3C of his memorandum of revenue, he made application at page 19.
It's cut, sir. There's already an order for.
Yes, my lord, it's a cover.
It is covered.
Similar.
All these 21.
But here the application is still pending, my lord.
Same order.
The item. No.
This date we can change preferably by 2nd January, so 2023. There's no coercive action, we'll stop it. We don't grant it here.
No.
Same order in how many matters?
It's 21, 22, and 23, my lord.
And item 50 also, that is under orders.
No, which are the matters, sir, please?
Item 21, 22, 23, and 50.
50.
Item 50 demand notice is there. In item number first 3 items, there is no demand notice, only representation. But in Annex 50, that is where the opposite department is the opposite party. And in that case, a demand notice and let him approach the authority, let him file the alternative appeal against that demand notice.
All right. As far as item 50 is concerned, you say counsel the appellant, the petitioner seeks leave to withdraw the present petition with liberty to avail of the alternative statutory remedy, which is the impugned demand notice in accordance with law. Disposed of is withdrawn with liberty is paid for. That is item 50. Right.
Supplementary list item 24.
My lord, item 24 to item 29, my lord, 6 item, my lords. This is the writ petition filed against the first appellate order, your lordships, in absence of the appellate remedy, your lordships.
You pay 10%
of the remaining amount, my lords.
So, your lordship, all these cases, item number 20% against the first appeal order there, let him deposit 20% of the.
Correct.
My lord, including the payment from the electronic credit ledger, your lordships.
No, your lordship. Electronic credit ledger, your lordship wants demand. Your lordship is well aware about that judgment your lordship has passed. That only on the face of the demand, when the demand has been raised, only that has to be paid as per the cash ledger, your lordship. Your lordship has passed the judgment. Your lordship, that is.
We will not get into all that. You just pay 20% of the demand.
My lord, I will take a few seconds from my lord, only a couple of minutes to your lordship. By the circular dated 6th of July 22, by the Central Board of Indirect Taxes already clarified that in case of demand tax, that can also payment from the electronic credit ledger. That is also clarified, my lord.
Just collect it.
GST कोई नहीं
Serial number 6, my lord. Whether the amount available in the
Yeah,
electronic.
this is different, sir. This is
My lord,
different.
for para 4, the solution para, accordingly, it is clarified that any payment was output tax, whether self-assessed in the return or payable is a consequence of any proceeding instituted under the provisions of GST law, can be made by utilizing
No,
the
here
amount
we are only,
available.
we are only talking of for granting stay of any further coercive action. That has nothing to do with this electronic ledger adjusting payments from there.
Your Lordship, the
You see-
provision is very clear.
Yeah, notice, he accepts notice. Since you write in the first, since this second appellate tribunal is yet to be constituted, the present petition is entertained. Notice, he accepts notice, reply be filed within 8 weeks. Adjourned up to the next date. This IA for dispensing with, that is allowed. IA for stay, you say notice, he accepts. Concept for the petitioner points out that 10% of the demanded tax has already been paid at the stage of the first appeal. In that view of the matter, subject to the petitioner paying 20% of the remaining demanded tax within 4 weeks, no coercive steps shall be taken against the petitioner during the pendency of the writ petition. This IA is disposed of.
My lord, I'm appealing all the
Obliged,
cases.
List on.
On 16 January, all the matters listed.
Pardon, my lord.
28 February.
Obliged, my lord. Pardon, my lord, item 50, I have alternatively, I will go for appeal, but the reimbursement of my GST, that is before opposite party 1, that may be direction, maybe as per that order. They have to reimburse the, as per the office memorandum, they have to reimburse the GST amount.
I don't know, whenever this is adjudicated, you point that
My
down to
lord,
the adjudicating authorities.
taken the GST amount, but they have to reimburse that as per Annexure 3 series, office memorandum, my lord. The opposite.
You pointed out to the adjudicating authority, sir, who's going to adjudicate the demand, challenge to the demand. Yes.
My lord,
Item 30 and 31, my lord.
Item 24 to 29.
Yes, my lord.
Item number 30.
Item number 30 and 31, your lordships. That is with regard to the rate of determination of GST on payment of royalty, whether at 18% of 5%. This issue has already been admitted by lord, and similar order may kindly be passed, my lord. And all the batch matters are fixed for hearing on 16th of January, my lord.
That is also against the first appeal order.
Yes.
Same order. Instead of 7th March, you see 16 January.
Yes, my lord.
16 January.
16 January, my lord.
Right. First order, 16 January.
Madam, I'm
Item number 31.
My lord, no, same item, my lord. No correspondence, my lord.
Yeah, same order.
Obliged.
Item number 32.
May I please your lordship? Your lordship, the present petitioner is a registered dealer under the GST Act with a registration certificate. My lord may kindly see Annexure 1. But the assessing officer has assessed him under Annexure 4, where he has treated him as an unregistered dealer. That is covered under Section 63 of the OGST Act.
It's an appealable order, sir.
No, your lordship, there is no appeal to it as the proper officer has assessed him as unregistered dealer.
Why no appeal?
No, appeal is there.
Why
Appeal
but
is there.
appeal not lies, sir?
63 order is appealable.
Appealable, correct.
My lord, appeal is not there. Your lordship may kindly see the kindly see Annexure 6 at page 29, my lord. I have made a representation that I have no scope under the GST law to assail the order before the appellate authority. Please guide us as to how I, being a dealer, can prefer appeal as an unregistered dealer and under which provision of the law, because the limitation to file appeal expires on 27/2/2022. After getting this, that the officer did not respond it, my lord. My lord, I am a registered dealer, my lord. I am registered dealer. My turnover is below 20 lakhs. 20 lakhs is the limit for exigible to tax, my lord.
What has that to do with filing an appeal, sir?
I am a registered dealer, my lord. I cannot file appeal. I am a registered dealer. Assess me as unregistered dealer, my lord. Unregistered dealer.
So you're not accepting that. But why can't you file an appeal?
Your lordship may kindly see.
Why can't you file an appeal? What is there to prevent you from filing an appeal, sir?
My lord, provision is there for filing of appeal in respect of registered dealer. But I am a registered dealer. How can he file the appeal as an unregistered dealer? That is my grievance before your lordship.
You say you're a registered dealer.
Yes, my lord.
A registered dealer can file an appeal.
Yes, my lord.
You're challenging an order, that's all. You're only challenging an order which wrongly categorizes you. According to you, it wrongly categorizes
my lord, please appreciate. Actually, I am a registered dealer. I have been assessed as an unregistered dealer by submitting an other's number.
Correct. So you're not accepting that, sir. You're not accepting that verdict. So you want to challenge that verdict. What is wrong? What is there to prevent you from filing an appeal? I don't understand why you can't file an appeal.
My lord, your lordship may kindly see.
Any person agreed, yeah. Anyone can file an appeal, sir.
My lord, your lordship may kindly file. I have filed the representation by.
That's not the way to do it, sir. If there's an adjudication order which is wrong in law.
Kindly appreciate, my lord. My lord, I am a registered dealer. How can I file appeal against me, treating me as a unregistered dealer?
So
let him take instruction, my lord. My lord, let him take instruction. It is a very peculiar case, my lord. It is a very peculiar case, my lord. Your lordship kindly look into it.
All right. What's your...
Actually, what happened, your lordship, Annexure 1, prima facie on the face of the record, your lordship. Annexure 1 is the registration certificate, which has been granted with effect from 9/9/2017. So 1/7/2017, the GST Act has been implemented. Pursuant to the GST Act implementation of the GST Act, he has migrated the GST. So at the time of migration, there are two types of forms. First, he has migrated, a registration certificate has been assigned. Subsequently, he has to file within 1 month the final form, which he has not filed. So for that 2 months period, he was unregistered. And your lordship, as per Annexure 2, your lordship may kindly turn to Annexure 2. In his migration number, he has get some amount. Your lordship, he has get the contractual receipt, your lordship. And for that portion, I am prima facie on the face of the document. For that portion, your lordship, he has been assessed as an unregistered dealer for those 2 months. What I prima facie on the face of the document, your lordship. So assessment has been completed pursuant to as a unregistered dealer under section 63. But that is appealable, your lordship. He can file appeal.
The petitioner's grievance is that although he's a registered dealer,
I may apologize, my lord.
He's been by the impugned order.
My lord.
I may apologize, my lord. I just want to supplement your lordships. In that case, my lord, the order has not been uploaded in the portal, your lordship. That's the problem we are causing, your lordships.
Yes, my lord.
Yes, that has been uploaded. Let me clarify. In one case also, I have handled that. That has been uploaded. And in that registration number and a particular registration, that particular registration, a separate ID is there. And that has been forwarded to his personal mail.
Yeah, I am on 17.
My GST number are not uploaded, my lord.
Instruction available.
Temporary ID. That temporary ID has been created being an unregistered dealer. And in that temporary ID, he has to file appeal.
He's a registered dealer, whereas the impugned order dated 9 September 2021 passed by the CT and GST officer, CT and GST Circle Jarsoda, proceeds on the basis that he is not a registered dealer. So on this basis, it is thought to be contended that the appeal can be filed against the said order. In terms of section
107.
107
of the
GST Act. 167. 107 of the Orissa GST Act.
May I just humbly interrupt you for a moment, Milords? Lord, once he's a registered dealer, Milord, he has a different portal, Milords. Now, if this order is passed, even though they are not permitted, Milord, to have another portal, Milords. So once they assess me as an unregistered dealer, Milord, my portal as a registered dealer will never reflect this order, Milords. So if it doesn't reflect, Milord, I have a difficulty in filing an appeal under 107, Milord. Your Lordships are very correct that any person can file an appeal. But unfortunately, since I am already registered, Milord, this particular order having been passed for an unregistered dealer, Milord, will not be reflected in my portal, Milords. So this online...
Once an appeal is filed and this order is...
No, it will not take, Milords, because appeal has to be against an order.
Temporary GST has been given. The ID has been given.
No, that ID is for an unregistered dealer.
That's right.
So I have to now log
file an appeal in the temporary GST, using the temporary GST. This order will get set aside. When it gets set aside, your regular portal will reflect it.
Exactly.
You say the impugned order. It is pointed out that the portal does not accept that the portal concerning the present petitioner would not reflect the impugned order, since it treats the petitioner as an unregistered dealer. Paragraph, it is pointed out by Mr. Mishra Leonard, standing counsel for the department, that in para 2 of the impugned order, the petitioner has been assigned a temporary GST IN number, and the appeal would have to be filed using the temporary number. Full stop. He added that once the appeal is entertained and if the impugned order is set aside, then the petitioner would be, then the portal of the petitioner would reflect the correct order. Would reflect the appellate order, which would be in substitution of the impugned order. Paragraph. In that view of the matter, while not entertaining the present writ petition, the court reserves the right of the petitioner to file an appeal against the impugned order using the temporary GST provided in the impugned order itself. Stop. If the appeal is filed not later than 19th December 2022, along with an application for continuation of delay explaining the delay on account of pendency of the present petition, shall be considered on its merits by the appellate authority. The court clarifies it has not expressed any view on the matter. The writ petition is disposed of with the above terms.
I'm sorry for the interruption.
No problem. Please.
This is happening, Milord, very Milord. They're creating an
temporary
ID, and we are unable to find out when we scan our portal, Milord, there's no order. All of a sudden, either an attachment comes or a notice comes. Then they say we have created a temporary ID. Then we have to go.
This whole GST regime is one work in progress still. They've not sorted out so many glitches.
But unfortunately, the officers concerned, they don't realize it, because they say whatever, just pay, then talk to us. That's the whole problem. Greatly obliged.
Right.
Item number
not set up.
May I please, Lordships?
33.
In this matter, your Lordships, pursuant to the SOCO's notice, I have already replied and say, but without considering my reply, they have issued the order. In my reply was based on the circular of the Learned Commissioner, that is under Annexure 20 under Annexure 2 series, Lordships. Along with my reply, I have submitted that this amount is related to pre-GST contract, and the payment was made in the GST
But same problem. Is it not an appealable order?
Your Lordship, 70 for order and all the factual dispute, Your Lordship.
No, not factual. Kindly have a glance at page 26, Your Lordships. 26.
Yes.
I'm sorry, Lordships, it starts from 25.
Yes.
This is the circular of Commissioner Commercial Tax and GST. where it has been clarified that para number 2, your lordships,
Yes.
work executed before 1/7/2017, but payment made or to be made after 1/7/2017. Next, since the work was executed in the pre-GST period, GST provisions are not applicable. So it is very clear that GST provision is not applicable for this period. And I have also annexed, and next page, in page 26, it is also clarified that the executant shall discharge his tax liability under the OVAT Act. So payment received by, so
No, the question is, this contention of yours has not been accepted.
he has not. He has not spelled one word regarding non-acceptance of this.
Your lordship,
But
page 34.
He has, but if it is, and says that at page 28, actual completion of work is 15/1/2017.
No, para 2.2, he's dealt with it. Why are you saying that? Page 34. Just
Page
see para
34, but
2.2.
2.2.
Yes.
Taxpayer has not, the taxpayer not come for personal hearing on dated 28/12/2021, but replied in DSC 06, stating that the amount is related to pre-GST contract, but they have not disputed the
No, we are not reading it completely.
Related to pre-GST contract work, but payment received in GST period, verified VAT return and GST return, and found that taxpayer has neither discharged his tax liability in VAT nor in GST. Under the circumstances, the undersigned is constrained and convinced to raise
So
demand.
it's not as if he's not considered. He has considered yours, but he says then you should have paid VAT.
Yes.
If
my
according to
prayer
you
is
this
that-
pre-GST, you should have paid VAT. I
Yes,
don't
Lordship.
find you have paid VAT.
That is my prayer before your lordship, that I may be, because VAT portal was closed.
That's all.
No,
You explain all that in
this
the
is-
appeal, please.
This is the prayer before your lordship. My prayer may be, your lordship kindly have my one glance at in my prayer, your lordship. My
No,
prayer
but
is
there
that
is this order staring at you. In the face of this order, we can't now permit you to pay the
no,
tax and VAT.
after that, they have again issued so-called notice, Annexure 5, your lordship. That is under section 73. For the period October 2007, the particular period when I got the payment. And if the order is passed for the 2017-18 period, then how this notice is surviving after issuance of the assessment order? After issuance of assessment order, again
So
another
you replied
notice.
to that. You have not replied to that show cause.
Because I may be permitted.
Your lordship, page 31, but that is, he has not replied, your lordship.
No, DRC 01, page 39. They have. Page 39, I have replied, your lordship. It grounds. Page 39, their summary of so-called notice, grounds. It appears that the taxable person has paid tax, but through utilizing his credit ledger, ITC, in contract. That means they have accepted my payment also.
No. Question is, you have to reply to this show cause notice.
I have replied.
No. This show cause notice you've not replied.
That they have accepted my payment.
My question to you is, this notice of 10th January, you have not replied.
But 10 January notice, I may be permitted to reply and.
You don't have to permit you can always.
Actually, if 10 January is the so-called notice date, which was to be complied in February, they have passed the assessment order in 31 January 2022.
Anyway, you say against the impugned order dated, impugned assessment order, bracket annexure 4, an appeal is provided, which the petitioner can well avail of. As regards annexure 5, the petitioner is yet to reply to the said show cause notice, and therefore it is premature on the part of the court to interfere at this stage, leaving the appellant to petitioner to avail the remedies available to the petitioner in accordance with law. The petition is disposed of.
Item number 34.
Your lordship, so far as the impugned order, he will file appeal.
No.
Yes.
Because
Whatever.
after that,
Can avail of the
Because the
remedies.
board both the things are different, Your Lordship. Both the proceedings.
Sir, if you not listen to the order, then I'm not going to waste my time repeating the whole order, sir. Sorry.
I'm sorry.
Yes.
Supplementary list item 34.
May it please, Your Lordships. May we permit you to address our Lordships on the video?
Yes, please. Yes, please. Yes, please.
May it please. This writ petition challenges in the order passed by the appellate authority for advanced ruling. We are, Your Lordship, we have entered into a contract, Bhubaneswar Municipal Corporation. Am I audible, Your Lordships?
Yes, please. Yes.
Grateful, Your Lordship. We have entered into a contract with Bhubaneswar Municipal Corporation, Lordships. What we do was street writing.
Right.
The term agreement with us is that I will supply all the lamps required, etc., some about thousands of them, and maintain them and operate them for 10 years. Okay. Every month, Bhubaneswar Municipal Corporation will pay me some percentage of the energy saved by them. They will not pay me anything else. Every month, whatever energy is saved by them, I will pay. At the end of the 10-year contract, the Lordships, I have to hand over whatever assets are left with them free at book value to them. That's the terms of the agreement. So there is a GST notification. I will show Your Lordship in a minute. Serial number 3 of the notification says, pure services rendered to a corporation are exempt from GST. So the condition of the notification is pure service other than works contract service. According to the lower authorities, since at the end of the contract period, after the contract is over, whatever assets are already installed by me.
No, just Mr. Sridharan, just one issue. This is an order which what you're challenging is an order dated 5th March 2019.
Lordship, yes.
So we are coming into 2022.
Lordship, because of COVID, etc. Plus one more reason, Lordship. We have been requesting the municipal Bombay, this order which operates for future also. As your Lordships are aware, this is an order of the advanced ruling authority and operates for all times to come. And therefore, we have been requesting Bhubaneswar Municipal Corporation to reimburse this GST because in terms of the contract with me, the liability is theirs. We were thinking once the state authority holds, I am liable to pay GST, and clearly in terms of the contract.
But you're not challenging any order passed subsequent thereto by the assessing authority.
Lordship, as per Lords are aware,
you have not suffered any. Looks like
no, Lord, but this order will be final and binding on me, Lordship.
No. I know what has happened after this order.
Nothing has happened, Lordship. So far, nothing has happened. So far, nothing has happened. No.
All right.
But Bhubaneswar Corporation also.
So we'll confine notice to prayer A then. Because all the others are only consequential.
One more, in case I fail in prayer A, Lordship.
Then anyway you can't get prayers B to H.
Lord, just 1 minute, Lordship. Which is very good.
All right. Notice
Lordship, item C also, Your Lordship, because this alternate notification which you raised before the authority, which has not dealt with it. So Lordship may issue notice D also will arise. If I fail in A, corporate has to reimburse me that, Lordship. And there are authorities. I'm not interpreting the contract. That's a matter just to go to arbitration. Admittedly, in terms of the contract, corporation has to pay me the either the state government says I'm not liable, the state government says I'm liable, corporation will reimburse me.
No, I don't know how this whole thing works. Suppose we interfere with the advanced ruling decision.
Lordship.
Do we substitute it with our decision? I doubt it.
Lordship, when your Lordship raises a doubt, I won't have an answer. But if it is an error of law,
No, I know. Then it can only go back, I think. This kind of a situation, it can only go back. I don't think the High Court can substitute the advanced ruling with its own ruling.
The Lordships have held so in Columbia Sports, following Supreme Court, that is an error of law. Say in income tax.
That's true.
But
whatever is the error in this kind of situation, it will simply go back, I think, to the advanced.
Could be, Lord. I will be happy with that also.
Yeah, that's right. Correct.
In any case, this is going back, Your Lordship. I would request Your Lordship sets it a day, then it goes back to the original authority. But consider that also is fair enough.
Correct. You said notice confined to prayer A.
At this stage, Your Lordship.
At this stage. All right. At this stage. All right. Mr. Satpathy accepts notice for 1.
I'm
1. And what about 3?
I'm for opposite, but not 2.
3, Lord, Union of India's tourism. Mr. Padi.
No, Commissioner and Union of India, I don't know, Lordship, whether they want separate people. On center and state, I can understand.
This authority itself will not file a reply.
No, he will not file a
Commission has to file a reply.
You said notice confined to prayer A and notice at this stage issued to opposite parties 1, 2, 3, and 4 and 7.
Lordship.
1, 2, 3, 4, and 7.
Lordship.
So he accepts for 1.
And for 2.
And Mr. Mishra for 2. Mr. Padi for 3. And Mr. Mohanty for 4. Then see, notice be now issued to opposite party number 7. Returnable. Additionally, notice could be served to any other standing counsel for opposite party number 7. Replies be filed within 4 weeks, rejoined of the next. 28th February.
Grateful. Pleasure. My pleasure, Lord. My privilege.
All right. Item number 35.
Here the limited grievance of the petitioner Miller to dispose of the grievance petition under Annexure 3 series.
Yes.
Because the business of the petitioner has been closed since 2012, but the demand notice has been issued. That is why I made the grievance before the OP number 1.
This new thing of this representation thing won't work in tax matters, please. All other matters, representation and all will work, not in tax matters.
Yeah, because
you either reply to the notice, you invite an adjudication order.
There is no notice to me because my business is closed since 2001. Annexure 1, your Lordship may see. Annexure 1, page 14. But now the bank manager has been noticed to block my account. That is why I made the representation.
No. Then if it's an attachment order, you challenge the attachment order. No, the representation route won't work, sir. If there's an adverse order as a result of which your account is frozen, is it?
My lord.
You have to ask for lifting of the attachment.
Because the sales officer has issued the notice. That is why
then you challenge the notice. The prayer is not.
I made the.
The notice.
The bank has attached the notice. The bank has issued me notice and attaching these notices of the sales tax officer. That is why I made the representation.
No, then you have to challenge those notices, sir. Representation doesn't arise. There's no question of representation. You withdraw this and file a proper writ petition. If the counsel to petitioner seeks leave to withdraw this present petition with liberty to file a proper petition in conflict of law.
Supplementary
post office withdrawn with liberty is paid.
Item 36.
Madam, 36 infructuous, your lordship, not placed.
Infructuous, all right. Infructuous disposal.
Item number 37.
My lord, item 37 here, the petitioner challenged the demand issued by the Superintendent of Excise, basing upon audit demand, my lord. Your lordship has already passed out.
Audit objection.
The dates have been changed?
My lord.
All right. Same order.
I have not changed, my lord.
The date has to be 31st December. A week thereafter.
Same, my lord.
38.
Item number 39.
39, my lord, no instruction. With liberty, if cause of actions are right, with liberty.
Because 6 matters has no liberty.
Protection of lawyer, man.
Right. No liberty. Just say no cause of action. It's dismissed.
Item number 40.
This is matter, lordship, regarding the consultation act, lordship. The petitioner made an application for
The petitioner made an application for allotment of Chakka lordship. Consolidation operation started lordships. In view of the consolidation operation, petitioner made an application for allotment of Chakka. Chakka was allotted to lordship, where major portion of land of him is situated. Now, where Chakka was allotted, prior to allotment of Chakka, there is a section 4 notification. Lordship agreed by the state, the present petitioner filed a representation before the authority. That was not considered. Then he filed writ petition. Writ was dismissed on the footing that since the section 4 notification is there, possession has taken, therefore contention of the present petitioner cannot be entertained. Now this is situation, lordship, kindly consider the present petitioner lost all his lands, lordship.
What are you challenging? You're seeking review of 24th March 2009 order, correct?
Lordship.
Kindly read that order.
Review order. This writ petition is had analogously with writ appeal number, another writ appeal, 56 of 2008. Whereas in the writ petition, a challenge has been made to the validity of various provision of the Odisha Consolidation of Holding and Prevention of Fragmentation Land Act 1972. On perusing the grounds noted in the writ petition and upon hearing learned and counsel the petitioner, we find no merit in this writ application since the land acquisition compensation in the case has been deposited in the name of the petitioner in the state treasury, and it always open for him to seek release of the said compensation amount in his favor. We are further of the view since the land in question has been acquired for the public purpose of irrigation canal, no objection to such acquisition can be entertained. Now, lordship, I am on a question of law, lordship. I am on a question of law whether the allotment given in favor of me by the authority when there is a notification, section 4 notification is vitiated or not. Lordship, Consolidation and Fragmentation Act, lordship, section 8 says, before allotment, the authority shall keep the land for the public purpose. Thereafter, Chakka shall be allotted. Now, this allotment made, lordship, in derogation to the section 8 of the and he lost all the lands. Lordship, section 8 of the PFL Act 1972, may I read, lordship, which say subsection 2 say, the statement of principle shall also contain the following details named. Specific area as far as they can be determined to be earmarked for such public purposes and to such extent as may be prescribed. The basis on which and the extent to which the land contribute the land for public purposes. Now all my lands are taken, lordship. I made an application for Chakka.
Yes.
The authority allotted me Chakka, where all lands have been notified by under section 4. Now I am a farmer with landless.
All right. Sorry, sir. No grounds made out for review. The review petition is dismissed. All right.
Now this aspect.
Yes.
Item 41.
None appeals dismissed.
Item number 42.
None appeals dismissed.
Item number 43.
Same one.
Item number 44.
None appeals dismissed.
Item number 45.
None appears dismissed.
Item 46.
None appears dismissed.
Item number 47.
47, Lordship, I pray for tomorrow because I don't have file. I'll copy Xerox it from the course record.
Pass it over, so you just see, give you the file. Pass over. Both. Yeah, 47. Sorry.
40. Item 48.
You see, the order dated 10th October 2022. Sorry, 2nd November 2022 is clarified by directing that a production warrant be issued against the respondent. Oh, or 1 minute. Sorry, by clarifying that a bail warrant in the sum of rupees 5,000 be issued against the respondent through the station house officer in charge OIC of the concerned police station. It is further clarified that a copy of this order be immediately delivered to the SHO bracket oblique OIC concerned along with the bailable warrant. First, you say the office note has been perused and then this. All right.
Item number 49.
No instruction.
No instructions dismissed.
Item 51.
May I please? Covered matter, similar order maybe 51, 55, 53, 54.
All right. Same order. 51, 54, and 55. All right. All right.
51, 55, similar, 53, 54.
51 and 55.
And then 53 and 54 is another set for.
Item 53 and 54.
This is the same revised guidelines. All right.
Item number 52.
52, Your Lordship, I'll serve the copy in this matter come on Monday.
All right. Defect be cured within a week, list thereafter. All right.
Item number 55, no, 56. Item 56.
56 in this writ application, the petitioner challenged the illegal action of the opposite parties in blocking the input tax credit. And in the meantime, they have already unblocked.
Okay.
So this writ petition has become infructuous.
Counsel, the petitioner states that the petition has been rendered infructuous. Disposed of as such.
Item number 57.
Item 57, the similar matter has been placed to 20th January.
All right. List on 20th January.
Item 58.
None of this. Oh, Passover. Okay.
58.
58 Passover.
Item 59.
And item 59 and 60, I pray for 1 week time to.
All right. Defects be cured within a week, list thereafter. All right.
Item 61.
My lord, in this case, against the first appellate order,
defects
remanding the matter, against the first appellate order, remanding the matter to the assessing authority, I filed second appeal. And I informed the same to the assessing authority, and the assessing authority under Annex 2 C, your lordship may kindly see page 52, my lord. Order dated 31/07/2019. The dealer appeared through its learned advocate and furnished the Xerox copy of receipt showing proof of filing second appeal. As the case is pending with higher forum, the hearing and verification of records record is stopped till the direction of upper forum. But after that, it passed the order of assessment against me.
No stay was there, no stay by the honorable tribunal. So he proceeded with the assessment order.
My lord, there is no provision in the statute for granting stay by the tribunal.
Now, this fresh assessment order is appealable. This 29th March 2022 order is an appealable order now again.
My lord.
I am respectful submission that appeal is pending. In the meantime, this order has been
so
passed.
now that appeal goes, you substituted by this appeal now. Counsel for the appeal. Petitioner seeks leave to withdraw the present appeal. Present petition with liberty to file an appeal against the impugned assessment order dated 29 March 2022 as well as the consequential demand notice. If such appeal is filed not later than 19 December 2022, accompanied by an application for condonation of delay, explaining the delay on account of pendency of the present petition, shall be considered on merits by the appellate authority. The court clarifies it has not expressed any view of the matter. Is there any original that you have filed? No.
Yes, my lord. I have filed the original.
The originals be returned subject to being substituted with attested photo.
Item 62. Item 58, my lord, instead of 57, my lord, item 58, your lordship placed that to 25th, my lord. Your lordship have passed over that item 58. That is, my lord, 58 to be placed, my lord, 25th January.
Oh, so you're not in 57?
Not in 57, my lord. I'm sorry for that.
All right. 57 is passed over.
Yes, sir. I am there. He has interfered. That's why I have remained silent. So this is the 57 my case. Okay. So two defect has been raised.
You will remove it.
7 days.
Okay. 57, you say defects be removed in the list thereafter. 58 list on 25th
January.
25th January. Right.
Item number 62.
My lord, in this case, I have challenged the appellate order under Annexure 7 arising out of cancellation of registration certificate alleging wrongful availment of ITC. Your lordship may admit this, and as an interim, I may be allowed to operate my RC because if there was any wrongful ITC, then the officer is entitled, obliged under the Act to assess me under Section 74. Instead of using that section, he has cancelled my RC. Appellate order at 47 page, my lord. That is appealable to the tribunal. Since the tribunal, that is
since the second appellate tribunal is not functioning, the present petition is entertained. Notice, he accepts notice on behalf of the opposite parties. Replies be filed within 8 weeks, rejoined for the next date. This IA, but this will be the final relief, allowing him to operate the registration certificate.
My lord.
His interim relief, have you seen the prayer?
Let me take instructions, my lord.
RC is cancelled, my lord. I am in nowhere, my lord. Without any business, my lord.
Instruction is required.
No, but why should he cancel the RC itself?
My lord, for any wrongful availment of IT, there is so many provisions are there for levying tax, penalty and interest for recovery and etc.
No. What happened during the pendency of the appeal? Because this cancellation took place in February 2020.
Reason for cancellation?
Wrongful availment of ITC.
No, but the cancellation has been in force since last 2 years.
My lord.
Then there's no hurry, sir. Then notice on IA.
Deposit money.
Deposit कौन? Because का nature.
28th February. Okay.
Item 63.
Lordship, the petitioner challenging the Annexure 1, the order of the Commission Appeal, which is the expired order passed without giving an effective hearing to the petitioner. And my prayer, the direction should give to opposite one to
pass fresh order giving effective hearing to the petitioner.
Anyway, you say since this second appellate forum is not constituted.
No, but here, here D. Satpathy is appearing. Here, Lord, that is Sestak is there. Lord, he is challenging the order of, I think, Lord, if I am correct, Lord,
Commission appeal.
Commission appeal. That is second appeal because Sestak, Calcutta. That is always there. Lord.
Oh, is there, is it? Okay, then you withdraw and go for that. Counsel to petitioner seeks leave to withdraw the petition, liberty to file an appeal as provided against the impugned order as provided in the statute in question.
Lordship, I pray for 4 weeks time to submit.
If the appeal is filed not later than 2nd January 2023, accompanied by an application for condonation of delay. Explain the delay on account of pendency of the present petition. It shall be considered by the appellate forum in accordance with law. The court clarifies it has not expressed any view in merits. This it's only a photocopy, so it's the petition is disposed of the appellants.
Will D. Satpathy, Junior Counsel name may be recorded.
All right.
Item 64.
Publish. May I please, Your Lordship? This present petition, Lordship, relating to reopening of assessment for the assessment of 1314 millards. This clearly, my lords, is well of. Yes, my lords. And
covered. Yes. In view of the decision of this court dated 21st January 2022 or 24 January 24 January 2022 in Ambika Iron and Steel, as well as the judgment of the Supreme Court in Ashish Agarwal, the impugned notice dated.
No. After that has been considered and fresh notice has been issued.
No, Lordship.
Of the Agarwal's case.
Here you're challenging 148.
Yes, this is bad by limitation as per proviso, first proviso to section 149(1). This 6 years has been elapsed, my lords. First proviso to section 149(1).
No. What is it? No. Original notice is on 30th June, sir.
Yes, my lords. Original notice was 30th June 2021. Thereafter, my lords, in view of judgment, bulk cases, my lords, 11 July 2022, my lords has directed to issue notice under section 148 capital A, my lords. Department is in view of this, my lords, my humble submission before your lordship is this 148 is a B notice itself invalid, my lords, because 6 years has been elapsed. So as per proviso to first proviso to section 149(1). Unamended. Yes. My lords, in this similar cases, my lords, Honorable Calcutta High Court had already quashed this notice, my lords.
In view of the Ashish Kumar Agarwal's case, my lord, the notice was, my lord, was issued.
No, but then
and that has been regularized.
Because of this proviso. We examined this 149(1) proviso. Because it is assessment year 13-14. Yes. It's hit by the proviso. Anyway, he says, concept of the petitioner contents.
3 years, 3 years, and it is, if it is considered, my lord, within the 6 years, my lord, 3 years and 10 years. As per
No. That's the main provision, sir. Proviso is different.
Specifically specified one date. 1st April 2020.
No notice shall be issued at any time in a case for the relevant assessment year beginning on or before 1st April 2021. This is an assessment year before 1st April 2021. If notice under 148 could not have been issued at the time on account of being beyond the time limit. If it was already time barred, you can't issue it now. That's what this means.
I'll take instruction on this.
Say notice, you see, counsel the petitioner contends that in view of the proviso to section 149, bracket 1 of the Income Tax Act 1961, the impugn notice dated 29th August 2022, issued under section 148, capital A, bracket 1, bracket B, in respect of assessment year 2013-14 is barred by limitation. Notice, he accepts notice, 6 time for instructions.
Will not stay up further.
List on 28th February 2023. In the next date, no coercive steps shall be taken against the petition. What is the date of this 148 A, B, 1B?
Let's see, 1st June 2022.
June. 1st June. All right.
Next item, same.
65.
Same.
Same, is it?
Similar.
All right.
Item number 66.
But you can grant me some time to remove the defects.
All right. Defects be removed within a week?
Malas.
All right. Is thereafter.
Can I just pray for 30th? 30th month subject to your lordship's kind convenience.
No, it will be listed immediately thereafter, I thought.
Much obliged. Much obliged.
Item number 67.
May it please, Milords, I beg to appear virtually, Milords.
Yes.
This matter, Milords, is quite similar to your lordships deciding in 64 and 65. Here also, Milords, the notice relates to assessment year 13-14. And in fact, it is one step better, where your lordships had already quashed the 148 notice by following Ambika Iron. Despite that, Milords, they have now issued 148A. And the notice having been served on 31/3/2021, it is not saved by the Honorable Court's judgment. And your lordship, anyway, the proviso to 149(1), your lordships just read out,
right,
that is applicable.
All right. So just say notice, accepts notice, same date, 28th February, till the next date, no coercive steps should be taken. All right.
Here also, Milords, the 148 notice, 148AB notice was 1st June 2022.
All right. All right.
Supplementary for orders, item 68. 68 will not pressed.
No, not pressed. Not pressed, disposal. Dismissed, not pressed.
Supplementary item number 70.
Is over.
My lords, I am appearing in item 70. This was the issue regarding the challenge to the validity of the FCRA provisions. Now, in the Noel Harper case, yes. Now, my lords, there were certain provisions which were not challenged, which were not subject matter of the Noel Harper case, which are the subject matter in our petition as the constitutional validity. However, my lord, we have also found out, we made inquiries from the registry. There was a petition which was filed before the Noel Harper case was heard, in which there were about 9 writ petitions, which were the subject matter of the transfer, not this writ petition. This was not the writ petition. So, I'm so sorry, this is 72. I'm so sorry.
That's what I was wondering.
I'm very sorry. I'm very sorry. I'm sorry.
All right.
I'm sorry.
All right.
Sorry.
70, my lord, I am for BDA, my lord. Last date order was there for to file an affidavit. Further 1 week time given to file affidavit.
All right. At the request of counsel for the BDA.
May I pray one thing, my lord?
Time for filing the in terms of the order dated is extended till 2nd January 2023.
My lord, another my lord, one WPC number 16758 of 2015, my lord. That matter is filed by the OP5 in this case, my lord. In that case, my lord, there was an order to this matter to be tagged up with that case.
All right, list along with that. Petition civil
number, my lord, 16758. Of 2015, my lord.
16758. 1st March 2023.
Oblation.
Supplementary list item 71.
Lord, this is a
so much of public interest litigation petition instituted at the behest of Legal Services Authority. Lord, here I am appearing as an amicus curiae to assist your lordship.
Yes.
Lord, the fundamental difficulties and Lord.
No, they were to file an updated affidavit.
My lord, I have taken instruction, my lord, in the last affidavit was filed on 13th May 2019. And in between there are so many developments.
That's what we gave you time, sir. Last time we passed an order in September saying an updated affidavit shall be filed by the state government before 1st November.
For that purpose, instruction that they may require some more time because they have to clarify the
position now. Let me tell you, lordship, it has come to my notice. There is already earlier an order permitting me to visit different schools and submit a report. Lord, due to this corona crisis, I have not been able to do that. I'll do that very shortly, my lord. I pointed out certain schools where the basic amenities are lacking. Your lordship knows Article 21, a fundamental right. Dropout, non-admission, non-availability of infrastructure, drinking water, separate toilets, classrooms. These are all, my lord, fundamental issues lying in different primary schools, my lord, and playgrounds. Lord, I had conducted a review. I mean, went to different schools. Reports are furnished by me, and they were all also recorded. But now, in the meantime, lots of time have passed in the meantime. Now I am required to visit some schools as a mark and submit a report to your lordship. For that purpose, your lordship may give me some reasonable time. I'll do that.
Mr. Rathul on amicus curiae states that he will visit a sampling of schools and submit a report to this court on the present condition. Meanwhile, before the next date, with an advance copy to counsel for the state. Paragraph. Mr. Mahapatral and senior standing counsel for the SNME department states that the affidavit in terms of the order dated 8 September 2022 will be filed positively 1 week prior to the next date with advance copy to the learned amicus curiae. List on. January 2020.
Right. I'll do that in the meeting.
17 January.
Item number 72.
My lord,
Item 72.
We have already.
Item 72, my lord directed to file a detailed counter affidavit. His lordship remember is a FCRA matter.
Correct.
The Supreme Court has issued the matter on 8/4/2022. Yes. But last occasion, my learned friend said that whatever matters and dealt with by Supreme Court, this application is different from this, and we have to get substantiate to the court in this regard. So they have prayed for 6 months' time. We will file a IA in this regard. My current friend is there, Mr. Pati will file a IA. This ministry required to move 6 weeks' time to file the detailed counter.
My lord, I mean, just apprise my lords what has happened. Just to complete the picture.
Yes.
There was the petition, the issues raised in the Noel Harper. There were some which were common to us and some provisions which we have challenged which were not raised in Noel Harper and was not the subject matter of Noel Harper. That is one part. Second, there was a transfer petition which was filed by the Union of India. I deem it my duty to inform this court. And in that transfer petition, my lords, ours was not the subject matter of the transfer. There were some petitions challenging the FCRA provisions in other high courts and including Orissa High Court. Now what has happened is, my lord, in that transfer petition, notice was issued and the proceedings were stayed and it was to be listed after the Noel Harper is disposed of. These matters are to be listed on the 25th of November. In those matters, again, my lords, except for one petition, which has some of the issues raised by us, the others do not have the same issue, number one. And number two, my lords, the other high court petitions which were there, except for Odisha High Court, all others have been withdrawn. So the purpose of the transfer petition had been conflicting judgments of different high courts. Now only Odisha High Court is there. That's coming up on 25th. Most probably, my lord, they're going to push that only one high court is left. And my lord, that may decide ours is not the subject matter of the transfer. So they may file a counter, and in the meantime, we'll apprise my lords of the next date. Hearings.
All right. Mr. Padi states that since the present petition seeks to challenge the
Amendment 12A.
you see, this IA is taken on record, numbered. You see, it's pointed out by Mr. Padi that since the petitioner seeks to challenge the Foreign Contribution Regulation Amendment Act 2020 on grounds other than those considered by the Supreme Court in Noel Harper versus Union of India. Give the citation. The Union of India may be granted 6 weeks time, to file a detailed counter affidavit. To stop, the application is allowed as prayed for. In the main writ petition, we say 6 weeks time is granted to the Union of India to file its reply. Rejoined, if any, they are to be filed before the next date. List on. February 13th. All right.
Lordship may reply along with me, Mr. Manoj Pati.
All right.
Item number 73.
Lordship, I am appearing in this matter. Lordship, may kindly allow me to share my screen. If you can ask the host to allow me to share the screen, because Your Lordship, I have to show some documentation in this in the case.
All right. Just permit screen share.
Obliged, Your Lordship. Lordship, so this is a case for assessee company for the assessment year 13-14, Your Lordship. In this case, Your Lordship, what happened was the company issued the notice under 148 on 8th April 2021, Your Lordship. However, the company, Your Lordship, has already been struck off in the year 2001 itself, Your Lordship. That is 20 years down, way back in 20 years. Lordship, still we have received the notice in the name of a non-existent company, Your Lordship.
No, but they were given time for counter. What happened?
I have to file counter.
All right.
It's pending.
Final opportunity to the department to file its reply within 8 weeks, reserved for the next date.
Your Lordship, just
interim order to continue. Yes. Yeah. Interim order to continue.
1 minute, if you allow me. Thank you, Your Lordship. Obliged. Your Lordship, one more thing here. I have to file some evidences in support, because here also,
you file it with your rejoinder.
Your Lordship, actually, that is very pertinent. Problem here is that there are two same companies. Konark Auto Spring Private Limited is an assessee company, and Konark Auto Spring Leave, which is a partnership firm. Now, what they have done is they have assessed the income in the hand of partnership, the same income based on the same reasons, Your Lordship. And the assessment has already been made, and the tax, the income has already been taxed in their hand. So, Your Lordship,
it's all right. Let them file a reply in the rejoinder. You can raise all these issues. Correct.
Obliged, Your Lordship. Obliged.
All right. Okay.
Your Lordship, the interim
1st March. 1st March.
Lordship, interim order may kindly be.
Yes.
Item 74.
I do obliged.
Lordships. My power is there, but I think my Oklatnama is not attached to that.
Okay. All right.
In this matter, Your Lordships, assessment is under section 43 only on the basis of AG audit, Your Lordships. Kindly have a glance at page 16, Your Lordships. The relevant part is para 3. On verification, the AG audit observed that as per entry number 113 of the Schedule B, Roman 2 of the Odisha VAT Act, textile is taxable at the rate 4%, subject to the explanation that textile fabrics shall not be subject to levy of tax under the Odisha VAT Act until it is subject to levy of duties of excise under the additional duties of excise foods actually, that is rated foods, but actually it is goods of special importance Act 1957.
Right.
However, by an amendment to the schedule to the additional duties of excise goods of special importance Act 1957, the Government of India by notification number 11/2006 CE dated 1/3/2006 exempted duties of excise on the textile fabrics with immediate effect. At this point, Your Lordship, I may be permitted to take a pause. The basis of the demand is based on the notification dated 1/3/2006. Pursuant to that, I have supplied one notification on clarification of Government of India, and it is also in the book.
They have not exempted, is it?
It is already additional duties of excise. It's also verily available on that day.
Leviable.
So no VAT is applicable on that date. So,
So once it is part of additional duties, it can't be subject to
cannot
that.
be.
Yeah.
So after that also in 2011 also another clarification was made by Government of India, and pursuant to that, Commissioner of Commercial Taxes also provided another notification saying that with remove this is so in 2011 and the last line, hence levy of tax on sugar and textile is effective from 8/4/2011. But after that, again in 16/7/2011, it was clarified, it is also in the book, that subject to the decision of the government when it will be levied. And it is also in the schedule itself.
No, which is the assessment period we are talking about?
That is 2006 to
39, 2007. We only have to see for this period.
Yes.
What's this additional duties of excise law?
It is already there.
No, it was leviable.
Additional
Textiles.
duties. Yes.
Textiles.
No, that. Yes, that was there. I have admitted that. 42 assessment was also covered under that.
No, but the impugned order proceeds on the basis that by this notification of 1/2006, it was exempted.
Yes, it is exempted. No.
If it
that
is
is
exempted
clarified
from the duty of excise.
No, kindly have a glance on that notification what I have submitted.
Where is that?
This is 3/5/2006. I am directed to refer to Government of Odisha letter number such and such, seeking clarification as to whether the state governments are empowered to levy VAT on AD goods with effect from 1/3/2006, consequent upon the issue of Government of India notification number 11/2020 in under challenge dealerships. This next bit, the additional excise duties is levied on sugar, tobacco, and textile in lieu of sales tax as part of tax rental arrangement with states.
So it's not exempted, it's only rate has become 0%. So it's not an exemption.
Not exempted.
So VAT will not apply there in view of this clarification.
Your Lordship, page 17 and 18 of the assessment order.
Continues. Correct. See, we are concerned only with the period 1/10/2006 to 39/2007.
Your Lordship.
That's the short 1 year period.
Your Lordship.
And during that period, it was still amenable to additional duty of excise.
Oh, bless.
Exactly. It's not exempt. Correct. We've not even seen this. Yeah, it's a 2010 order. We've not been shown this. Challenge the present petition. We'll proceed to quash. Challenge the present petition is to an assessment order dated 1st October 2010, passed by the Deputy Commissioner of Sales Tax, Baleshwar Circle, Baleshwar, for the period 1st October 2006 to 30th September 2007. Holding that the petitioner dealer, that the taxable turnover of the petitioner dealer on sale of textiles was subject to value-added tax under the Orissa Value-Added Tax Act 2004 (OVAT Act). So the basis for the impugned order, assessment order, is that by virtue of an amendment to the schedule to the additional duties of excise (Goods of Special Importance Act 1957) ADE Act duties of excise, additional duties of excise AED on textiles was single quotes exempted, unquote. Full stop. Consequently, it was held that in terms of the explanation to Schedule capital B bracket part 2 to the OVAT Act, textile fabrics were amenable to VAT at 4% after 1st March 2006. Paragraph. Perhaps not brought to the notice of the assessing authority that by a separate clarification dated 3rd May 2006 issued by the Ministry of Finance, Department of Revenue, Ministry of Finance, Government of India, it was clarified that the AED would continue to be leviable on goods described in column 3 of the first schedule to the ADE Act, although the rate had become single quote 0%. Stop. In that, in other words, it was clarified that textile fabrics would continue to be amenable to AED. And it was asserted that, open quotation, the central government retains the right to levy AED on these items in future, if so decided, unquote. The net effect of the above clarification is that textile fabrics are not single exempt, unquote, from AED under the ADE Act. During the period in question, that is 1st October 2006 to 30th September 2007. Stop. As a result, textile fabrics would not be amenable to VAT in terms of the explanation to Schedule B bracket part 2 to the OVAT Act. Paragraph, since the very basis of the impugned assessment order stands removed by virtue of the clarification issued by the central government on 3rd May 2006. The impugned assessment order is unsustainable in law and is hereby set aside. The writ petition is allowed in the above terms, no order is discussed.
Item 75.
Malad, I'm appearing in 75 minutes. May please. Yes. I'm appearing on behalf of Mr. Jagaban. So, Malad, the matter has become infructuous.
All right. Petitioner states that it's become infructuous. It is disposed of as such.
Malad, I am appearing for you.
Note 76.
76, Malad. 1 week time may be given because Mr. Mahapatra will argue the case. So, no counter has been filed. We have challenged the attachment order, Malad. So, that's why Malad it needs necessary to argue, Malad. I have to prepare. So,
what's the matter about, sir?
Matter, Malad, they have no authority to issue attachment order, that is under Annexure 6 and 10. And Mr. Mahapatra will argue what his personal difficulties is not Mr. Manas Mahapatra, senior counsel. His personal difficulties today. Any date, Malad, will come. And even if no counter filed till today, Malad.
Who's for the department?
Income tax department. 76.
No counter affidavit appears to be filed in this petition till date by the Income Tax Department. Although notice was issued way back on 24 December 2014. Paragraph, copy of the writ petition be served on Mr. T.K. Satpathy.
No, Mr. Sambalpur is happy.
A copy has been served on Mr. Mahapatra today, and he seeks time for instructions. Interim order to continue. List on 1st March.
Item note 77.
May it please the Lordship. My Lord, this is a matter under Income Tax Act. The proceedings, so notices were issued and assessment order was passed against the deceased SSC, my Lord. The SSC died on 15th April 2018. And my Lord, the notices were issued on 9th August 2018 and 26th September 2018. And the assessment order was passed in December.
Against a dead person, sir. That is covered now.
appeal provision is there.
No, please, please. The impugned assessment order was admittedly passed against a dead person. In fact, the notice preceding it was also issued to a dead person. We'll stop the assessee in whose name the notice was issued expired on?
My lord, on 15th April 2018.
15th April 2018, whereas the notice was issued on 9th August 2018.
And 26 September 2018 also.
And 26 September 2018. Paragraph, the legal heir certificate dated 29 June 2019, as well as the death certificate dated 15th April 2018, have been placed on record and have not been disputed by the department. Full stop. In that view of the matter, in view of the settled legal position that proceedings cannot continue against a dead person, the impugned notice dated 9th August 2018, December 2018, and the consequential assessment order dated 17 December 2019, as well as the demand notice issued by opposite party number 2 are hereby quashed.
But there are two notices. One more notice of 26 September 2018.
We've quashed that also, sir.
May I pray one thing, my lord? May I pray, my lord? Department may have liberty to, my lord.
No need for liberty, sir. Department needs liberty. Not at all. Department never waits for anybody's liberty.
To proceed further as per law.
Yes. Yes. All right.
78 at 2 p.m.
78
at 2 p.m.
Taxes will continue.
Supplementary list item number 79.
Applies, my lord.
Pardon, my lord. Item 78, my lord.
78 at 2 p.m., sir.
My lord, sub item.
2 p.m.
2 p.m.
Sorry, my lord. Item sub item double PC number 1069 22, my lord. This is not a similar matter. It is a single bench matter. I have told already in the again listed, my lord.
No, just wrongly listed, sir. The direction is already there.
Oh, bless me.
Item number 79.
May I please, your lordship? Lordship, in this present case, your lordship challenging to the order, reassessment order, my lords, passed under the old provisions of the Act, my lords. Lordships, the regime recorded for reopening has never been supplied, my lords, in spite of repeated requests, my lords. So, lordship is well aware of my lord that there is a honorable
GK and drive shafts.
yes, my lords, has not been followed.
Yes, sir.
Lord, the lordship see annexure 5, turning page 25. In my counter, I have stated in the draft order, we have communicated and explained the reason. Before proceeding the final assessment order, we have issued the draft assessment order. In there, we have explained the
Is that
reasons.
enough? I don't know.
No,
That's not enough.
but that is the, Lord, I can develop more. Lord.
You see, the short ground on which the impugned assessment order
That objection will be reflected
under section 148 of the Income Tax Act 1961, dated 31st March 2021 is challenged. For the assessment year 2014-15 is challenged. Is that the reasons for reopening of the assessment were never supplied to the petitioner, despite repeated requests. Paragraph in the counter filed by the department.
Paragraph 7 may kindly consider.
It is thought to be explained in para 7 that although reasons were not provided to the petitioner initially, in the draft assessment order issued under section 144 capital B of the Act, those reasons have been set out. Paragraph, the requirement for supplying reasons for reopening the assessment is mandatory, as has been explained with the Supreme Court in GK and drive shafts. We have to give the full citation. Versus ITO, what's the citation? 2002. Why SCR anyway? Supplementary CR 359. I'm sure there's an ITR citation.
Yes, not ITR. I'm just giving you.
Consequently, this court has no hesitation.
259 ITR 19 minutes.
259 ITR 19 bracket SC. Consequently, the court has no hesitation in setting aside the impugned notice dated 31st March 2021 and the consequential assessment order dated 28th March 2022. Full stop. This will, however, not prevent the department from proceeding afresh in a court, if so permissible. The petition is disposed of the above terms.
Item number 80.
So may I please, my lords? Item 80, my lords. Yesterday I received the counter, and your lordship may kindly, my lords, see the notings in the cause list, my lords. Previously, notice issued in main case returned unserved with postal endorsement, factory closed, returned to the sender. That's process fee filed. Because the company is Orissa's private opposite party, OP number 6, Millars.
Yes.
No notice could be served. Because I have filed today memo, Millars. Now CIRP proceeding is going on, and the now notice is to start on the resolution professional matter. I have given a memo to your lordship, Millars.
All right. The memo of the petition is taken on record. In terms thereof, notice to opposite party number 6,
My lords.
both in the writ petition as well as IA 11435 of 2022, will be served on Mr. Vijay Kumar V. Iyer, resolution professional for OCL Iron and Steel Limited, at the address given in the memo.
My lord.
Returnable on the next day. List on 8th March.
My lords.
Sorry, 9th March. 9th March.
Item 81.
Item 81, your lordship, in course of day we are filing counter.
All right. Counsel for the state states that he'll be filing reply during the course of the day, rejoined for the next date. Is there an interim order?
Your lordship, it is against the your lordship, so subject to
Oh. Rejoined for the next date, list on 9th March. All right.
Item number 82.
82 and 83, my lord, I have already filed rejoinder on the 10th of this month, my lord. This has not been kept on record, my lords. May just pray may be taken up next week, my lord, along with the rejoinder, my lords.
All right.
So,
rejoinder be brought on record. No, what's the urgency?
Urgency, my lord, the refund, my lord, it's an inverted tax duty, my lords, where the petitioner, my lord, he manufactures electric vehicles, my lords. And the batteries are imported where the rate of tax, my lord, is 24% GST, my lords. I sell my vehicle at the rate of 5%, my lords. So these refunds which are being flowing, my lords, are being locked up, my lords. And my entire industry, my lord, has now come to a standstill, my lord. And my mounting debts, my lord, to the various banks from which I have obtained loans, my lord, is also there, my lords. Lordship, kindly, I'll just pray for next week, subject to your lordship's kind convenience.
I'm just trying to see which date will be convenient. I think 21st December. 21st.
Pray for an early date, my lords. Because the entire industry, my lord, now, my lord, the banks have started, my lord, issuing notices under the Securitization Act.
1st December. Take a chance on
1st December, my lords. Greatly obliged, my lords.
82 and 83.
82 and 83. No? The rejoinders may be brought to record.
Or
item number 84.
Oh. 2 p.m.
At 2 p.m. Another matter, my lords. That is 87. 87 and 88. 87 is with Tushar Khan Satpathy and 88 with Mr.
Sunil Mishra.
So both the sides, both rivals are there. My lords, I could not concentrate on these two items because I was digging trenches. And he has got, they have got a armored division, that is Punjab Haryana High Court. So I was, whole night I was concentrating on this matter.
All right.
So praying that these two, 87, 88, may be taken up any date which is convenient to your lordships.
All right. At the request of Mr. Rai, both these matters, separate orders. Well, list on 9th March.
Obliged, man.
84 past. 84 past.
84 2 p.m.
Item 85.
The memo is taken on record. No instructions. Dismissed. Right.
Item number 86.
86, my lord, infructuous, both
infructuous, both matters. Dismissed.
Item number 89.
Yes, Mac.
May I please, your lordship?
Yes.
In this matter, there is an order, lordship, which is annexed at page 12, lordship, passed by this honorable court, page 12.
That's what?
13/12/2007 order, lordship. Heard counsel appearing for the parties by means of this represent the petitioner has prayed for a direction to the opposite party to comply the order of release of money passed by the Deputy Director Finance and further for a direction to pay the amount as calculated with 14%. The petitioner is that his EMD is not being released in spite of the direction issued by the Deputy Director Finance. Therefore, considering the facts and circumstances of the case and without going into the merits of the case one way or the other, this writ petition disposed with the direction to opposite party one to consider representation which shall be moved before him along with a certified copy of this order regarding payment of dues to him directed by the Deputy Director Finance and a region order to be communicated to the making payment or shall make expeditiously prepare production of. Now, lordship, when we went to the authority, lordship, we found this industry has been disinvested. That is by the IDCO. The agreement is, lordship, at page 17. Agreement which started at page 16. Now, the operative portion of the agreement, lordship, which said the Industrial Development Corporation, Government of Odisha, a company incorporated under the Companies Act, having a registered office, Sadar Patel Hall, Odisha, referred to the vendor, which expression shall, unless repugnant to contest, mean and include his successor in business. First part, lordship. This is IDCO. Now, lordship, Bhasa Fabrics, with whom my man has undertaken work, lordship. Then Indian Finance Limited, a company, Companies Act, having its Russell Street. This is a third part. Now, lordship, whereas the company is engaged principally in the business of manufacture and sale of electrical transmission lines, wide range of structurals, SR and the AAAS aluminum conductors, and having its manufacturing facility state of Odisha. The government of, this is important, my lord. The government of Odisha is the sole beneficial and legal owner of the entire issued share and paid up share capital of the vendor. The vendor in sole legal and beneficial owner of 85% equity share of ₹10 each fully paid up, constituting 100% of the entire issued, subscribed and paid up equity share capital of the company as per details in Special 1 hereinafter. Transaction share free, this is important, free from all encumbrances and along with all the right and benefit and risk and obligation attached thereto. Then important, lordship, clause D, the vendor in its capacity as the holding company of the company continues to exercise due control over the company, its management and business activities pursuant to the decision of the government of Odisha. Vendor, the vendor decided to divest its entire interest in the ownership of management of the company. Accordingly, offers were invited. Now, lordship, then important, lordship, is page 21. This is closing date shall mean and be the same as the date of execution of this agreement as such subsequent date as will be decided by the company vendor. Most important aspect, let's see, is page 24. On the closing date, the vendor shall sell and the purchaser shall purchase the transaction shares for the purchase price free and clear from all lien and encumbrances, and together with all rights and benefits and liability and obligation now and hereafter attached thereto. Let's see, my humble submission is, let's see, prior to this invest, let's see, IDCO, who entered with the agreement, let's see, categorically stated that the HIW, the company, has got no price to pay clear from all lien and encumbrances. Therefore, Lordship, what I am submitting, Lordship, this my order, the order which was passed against the HIWL, Lordship, since HIW has been disinvested by the IDCO, IDCO owes the responsibility to make the payment of my EMD, Lordship. For that purpose, Lordship, kindly come to Lordship page 56, and I have got many judgments, Lordship, to satisfy. One thing must be in the mind of my Lord, whether this can be entertained in a writ petition. That I'll satisfy my Lord. I have got 10, 20.
So you're not arguing a writ petition, you're arguing a review.
Review is admitted, Lordship. Review is admitted.
Which means it is allowed. Admitting means allowed.
Review is admitted, Lordship.
So admitted means you don't have to argue the review petition.
Review, what happens, Lordship? I am arguing review petition as because I could not appear on that day. The order, my Lord, mind of my Lord, the review order, and the order, my Lord.
Page 13, sir. Page 13 of your review petition paper book.
Review petition.
I don't even have a review petition. Of your review petition.
Let's see. None appears for the petition.
So what? Still, you have to argue the review petition.
Lordship, in this footing, Lordship, the order passed by the in this review petition, Lordship, which is challenge here, Lordship, because I could not oversighted the leads, Lordship, which I could not appear, Lordship.
Anyway, it's a money claim, sir. It is anyway a money claim.
Calculated amount, Lordship. I'll satisfy my Lord. Kindly adjourn it for tomorrow. I have got all the judgments. All the judgments.
Who's stopping you?
All the judgments.
Who's stopping you, sir?
I have got 10 judgments.
So you can cite 50 judgments also. You're not adjourning it.
Judgments, which can I
no problem. You cite even 50 or 100 judgments. We are not adjourning the case.
I'll try to
do that. You please try. We have not hurried you. Have we stopped you, sir?
No.
Have you hurried you?
No, sir. First aspect, Lordship, I would like to say before my Lord, it's a calculated amount.
All right.
Second aspect, Lordship, government company.
So that you argued now for the last 20 minutes. We have not even stopped you on this government company taking over, IDCO, all that you've argued. Don't repeat.
Lordship.
Now, what is your third point?
Third point, Lordship, the denial by the government company that we don't owe any responsibility, which is illegal in the putting, Lordship. They have accepted all the considered amount.
All right.
And they say if it is lien from all income races.
Correct.
Lordship. To that effect, Lordship, I would like to take, my Lord, the judgment. First, what is in the mind of my Lord, the judgment. Lordship, it is reported in 2009 to SCC 655. This is regarding maintainability, alternative remedy, exhaustion, alternative allotment, cancel allotment, instrumentality, challenge to proper forum if a matter specific relief act not entertainable by a writ court, writ held is maintainable. Lordship, Lordship may read the order, only 2 pages. They are after. Challenge in this.
No, don't start off now from para 1. Read the relevant portion, sir. Because we are indulgent, don't please start off like this from para 1.
The ratio.
Kindly read the operative portion or the ratio of it.
Para 4, Lordship, the appellant has categorically stated the subject matter of the challenge was the impugn decision taken by the corporation to repudiate the contract. The High Court erroneously, according to the applicant, came to hold that it can be considered by a civil court or competent jurisdiction. Learned counsel for the appellant further submitted that no reason has been indicated as to why corporation decided not to go ahead with the contract. Learned counsel for the corporation, on the other hand, submitted that the corporation decided not to take any note of made by the Everest retailer. In fact, the resolution taken earlier related to the present appellant. It is clarified by the learned counsel for the appellant that he is a director of the private limited company. The register indicated have no relevance. We find that this is a case which could have been decided by the High Court, and therefore we set aside the impugn order of the High Court. The writ petition shall be restored for disposal on merits. This is regarding, Lordship, maintainability of the writ petition. Second, this is report decided on 11/7/2003, High Court of Rajasthan, Lordship. I'm just reading the placitum, Lordship. Rajasthan Cooperative Societies Act 1965, Section 75 and 128 of the Constitution. Article 226, writ maintainability of alternate remedy available to the petitioner held limitation of jurisdiction under Article 226 of the Constitution is not absolute. In exceptional cases like present in hand where 8 years have elapsed, case can be decided on merit instead of throwing away on the ground of alternative remedy, writ maintainable. Then let's see. Then let's see. This is in the High Court of Andhra Pradesh at Lordship, this is reported on 2002, Lordship.
You don't want us to have lunch, but that is okay.
Lordship, I have forgotten. Because
No. We thought you'll get very upset that we are not preventing you from arguing. We are waiting. We are waiting.
Lordship,
We are waiting.
I have not seen.
We are waiting. No, but you will not conclude, na? So naturally.
No, Lordship, I have not seen the watch, Lordship.
No. You're dedicated, sir. You're totally dedicated.
Lordship,
We can see
Lordship,
that.
kindly come after lunch.
No.
Lordship, kindly.
We have other matters, sir, and we are not postponing this. You cite the judgment, whatever you.
Lordship, after judgment, I have to argue because I Supreme Court some judgments also there. This is Lordship, the merits Lordship is to decide whether my writ is maintainable or not, Lordship. There is certain judgments which will
2 o'clock.
Or next tomorrow, Lordship.
2 o'clock is an excellent time, sir.
No,
we'll have had lunch fully alert.
Lordship,
be alert, fully alert.
Lordship has fixed
You also have your lunch 2 o'clock. All right.
In item number 90, my lords, the JTF members are online.
All right.
Professor Sukumar
And professors, more particularly Professor Sukumar is online,
right,
which is special invite to that.
Correct.
My lord, I file an IA, my lord. Kindly appeal on the
One by one, sir. One by one. Where is the
Asun.
Please. So you first apprise us what has happened so far. No, you tell us, Mr. Mark.
Yes, my lord. My lord, we have filed an affidavit enclosing two minutes of the meeting. On 19th October and another is 3rd November. That is most important. Only these two minutes we have annexed to our affidavit. And the concluding part of the affidavit, your lordship may kindly have a glance at page 24. I'm sorry.
There's a draft framework of the comprehensive action plan.
Yes. And it will be, page 17, that by the end of 31st December 2022, we will complete the action plan.
Okay.
Comprehensive action plan will be completed. And the JTF has already been constituted. They are working on it. And more particularly, the expert member, Mr. Sukumar, he is, I think, and he is also acting on this. Yes, he is there.
Commission will submit, my lord. After submission of the report, we will submit to your lordship. After submission of the report, we will submit to your lordship.
Yes. That is obvious. Yes. Another, if your lordship will permit me, I will make a submission before your lordship.
1 minute. The officer next to you is the person next to you.
I don't know.
Sir, namaste. Sir, ମୁଁ के दीपिका बरमपुर आसली बेल कैंसलेशन ऊपर सर 3 मास हलानी किछि भी मोर डेट बाहरनी प्लीज किछि करंतु.
She has filed a petition for cancellation of bail and she wants to mention it before your lordship, but last 3 months it is not listed. That is why she is praying for
Or ask her to just give the memo.
যদি মানে শুনুনাহাନ୍ତି প্লিজ ଆଉ କୋ କୋର୍ଟ को ट्रांसफर କରନ୍ତୁ
Or memo All right. Has she left her contact details or something so that the DR can tell her which date it is?
DR को contact करिए deputy registrar
No.
मोबाइल नंबर टा सेतिर आपण अन्य मोबाइल नंबर टा सेतिर पेन हां
Mr. Sukumar, no, you've been through this comprehensive action plan. Have you examined it or?
Your Lordship, what we done in the last meeting which we held in Bhubaneswar?
Yes.
We had an in-person meeting in Bhubaneswar.
All right.
We have given our suggestions about how to structure the comprehensive action plan.
Okay.
The situation in Odisha is kind of not symptomatic, the elephant situation.
Yes.
It's the most challenging, of all the 4 regions in India where elephants are found.
Okay.
And Odisha, along with Jharkhand, has witnessed major changes in the last 40 years or so.
Okay.
And it needs a little more time to look at much more carefully.
No, actually, it is all, it gets complicated because of the man-animal conflict situation, the preventive situation, that is villagers themselves trying preventive measures by putting electric fences or traps for, capturing wild animals or preventing wild animals, like what is meant for the boar. The elephant gets trapped there. And then of course, you have the problem. So it's all somehow it's like a mixed kind of a thing. And then there's also disease and poisoning. We don't know from which source.
Yes, Lordship. I'll confine my remarks to the scientific aspects or the ecological aspects of what's actually been happening there. One is, of course, as you rightly pointed out, you have illegal, deaths of elephants. By illegal, I mean farmers have put an electric wire, which they shouldn't put out in the farm because they have tapped the electricity mains, the 230 volts. It's really meant for wild pigs, and an elephant comes into contact, and then an elephant dies. In a few cases, of course, there will be deliberate poisoning or deliberate killing of an elephant, which today is perhaps not as serious as the other form of unnatural death, which is what I call accidental deaths. So the accidental deaths are taking place primarily because elephants, Odisha, but also Jharkhand, Chhattisgarh, in many other states in the country, are today appearing in areas which are not their original home, 50 years ago or 100 years ago. So there are a huge amount of dispersion and migration of elephants are taking place. And this is more so in the central Indian region, Jharkhand and Odisha especially. And elephants have tried to colonize southern Bengal where there is no natural habitat for them. That's my scientific opinion. Elephants have gone into Chhattisgarh, but they are not staying there. They are also going into Madhya Pradesh and even into Maharashtra. And there's a lot of conflict. So the way I see it is that there has to be a much greater focus in elephant conservation, which is not only for this region, but for the country as a whole. And in this respect, I point out that some years ago, the government of India had set up a committee for an action plan for the East Central Indian region, that is specifically this region. And we all put in a lot of effort and we came up with what I believe is a very practical and pragmatic draft, but that has not seen the light of day because it is there in the Ministry of Environment and they have not.
No, but are elements of that plan come into this comprehensive action plan?
Yeah, yes, Lordship. I think definitely they will have to come into this.
No, they will have to, meaning they're not already there, or will you suggest that they put it in this?
I will certainly suggest that they put that into the Odisha action.
Do they have a copy of that central government? What was?
Yes, Your Lordship. I have provided the Forest Department, Odisha Forest Department, a copy of the action plan for the whole region, which was given to Ministry of Environment and Forest.
This, whatever they're planning, that by end of December, is it realistic? Is it doable?
I think we can only have the elements of an action plan. On the ground, the situation is because there is a huge churning out of this particular region with the elephants moving out. What complicated the matter, Your Lordship, is about 20 years ago, if you may permit me to say so, there is a regional institute for remote sensing. And they were entrusted with the task of preparing, a list of the elephant corridors in Odisha. And unfortunately, I personally believe they made a lot of mistakes. They did not know the ground situation, and they have arbitrarily drawn lines from one forest patch to another forest patch, merely based on the presence of elephants here and there. And many of these corridors are totally impractical and totally viable. They only serve to increase conflict.
Okay.
Contain conflict. Because a line between two forest patches 80 kilometers long and 100 meters wide, no elephant or no elephant herd will walk in a straight line between two forest patches.
Yeah, correct.
And many of these are not viable. So what I have basically suggested to the Odisha Forest Department, and I have done a report for them, that essentially the elephants of Odisha in the long term will survive in two landscapes. One is the Simlipal landscape, which is a very large area, and where you have about 7,000 square kilometers, where that should really be the main kingdom where the elephants are largely protected. The second, Your Lordship, is the Sambalpur Elephant Reserve and the Mahanadi Elephant Reserve. And I have done a report for them some years ago where I have given that there is a connectivity between these two elephant reserves. That connectivity should not be further broken. There are a lot of villages and settlements between that. And I have given suggestions for strengthening of these two elephant reserves such that that is a second landscape. And these two landscapes can hold 75% of Odisha's elephants. The rest have to be looked at and a few have to be managed. Some areas we have to keep them free of elephants.
No, the other thing I wanted to ask you is, how do we involve the communities, the villagers themselves in this whole action plan? Because they should not see this as adversarial to them. The minute they see that this is against them, they will refuse to cooperate or they may resist even its implementation. So how do we get them to adopt this and cooperate in taking it forward?
Absolutely, Your Lordship. I think we need to get the help of NGOs or both have the confidence of local communities as well as whose heart is in wildlife. Let me put it this way, because in conservation, have sometimes groups that are extreme. They take an extreme view, only wildlife and no people. On the other hand, only people and no wildlife. So we need to involve NGOs who can win the trust of the people, along, of course, with the Odisha Forest Department, and then try to rope in the cooperation of people. But,
because this loss of crops and danger to life, I mean, that's the uppermost concern for most villagers. And they act irrationally because they think they have to protect. And they feel that the state is not present at all to help them, so that they have to resort to their own measures. And that complicates issues, doesn't it?
Yeah, absolutely, Your Lordship. In fact, there has to be a very close partnership between the Odisha government or the Forest Department and the local communities. And a community-based mitigation, I still believe the primary responsibility is still with the Odisha Forest Department in providing the material, the resources, expertise, and so on. But definitely, once you have to empower local communities to come up with their own solutions. That is one thing, Your Lordship. The second thing, Your Lordship, is that in the state of Karnataka about 10 years ago, I had the privilege of being the chair of the Karnataka Elephant Task Force. And we spent 1 year and we had the best minds in the country in terms of elephant ecology and management. And we came out with a very pragmatic plan where we said, we give a zonation to the elephant habitats of Karnataka. So we said the elephant conservation zone, primarily the intact forest areas where elephants are found. 90% of Karnataka's elephants are found there. The second is that if you take the landscape approach, which is the way that we should go in terms of future conservation, then there will be settlements because these are all historical. So there will be an interface between elephants and people. There, all the community-based management and so on and so forth, villages, agricultural crops. But we also said there have to be certain areas which have to be kept free of elephants because they are totally 90% agricultural areas where elephants should not actually be there. But Your Lordship, if you again permit me to say, sometimes the conservation is, I'm not talking about time. The country is going in such a manner that certain groups want elephants to wander wherever they want to wander and only people adjust. That is not a feasible option, Your Lordship, in my opinion. So we have to bring greater focus, Your Lordship.
Okay. Thank you. Can we ask somebody from the JTF?
So all the JTF.
No, but any one person whom you can name who can make a presentation.
Mr. Chairman. Mr. Panda is the additional SP. Mr. Panda is there. He is the.
Mr. Panda?
Jatin Panda. Mr.
Jatin Panda.
Sir.
Not a good.
And Mr. Manoj Nair is there. He's the principal CCF. He's the chief conservator of forest.
All right.
Mr. Manoj Nair.
Okay. Any one of you can. Yes, please.
Mr. Nair.
Sir, namaskar, sir. This is Manoj Nair, sir.
Yes.
Sir, may I proceed with your kind permission?
Yes, please.
Sir, ever since JTF came into picture, sir, with the kind directions of your honorable court, from the 13th of August onwards, we have been actually looking at all these things very, very carefully, sir. We have also managed to rope in some of the best people in the country, sir. We do have some best practices already in place, which we can borrow from other states, sir. And on the ground, sir, we are completely in agreement with your very perspicacious suggestion, sir, that unless we have people on board, sir, we will not be able to do much. So that will be also the primary focus that we plan to put in the action plan, sir. We have already initiated dialogues with some of the potential NGOs that we can work with. We have already started opening dialogues with honorary wildlife wardens of the respective districts, wherein we can think about how people can be roped in. Alongside, sir, what we have done is that we have ensured the presence of JTF members in each and every case of unnatural death, Your Lordship, so that a lot of cases which was probably ascribed earlier to other reasons, disease for instance, sir, have been now with our very very close oversight as well as handholding, have been proven to be that of electrocution, sir, which I think is a major finding even for us. So that electrocution has assumed dangerous proportions has become very clear, sir. And this is something we also look at it very closely, sir, actually. And as a result of which, sir, we also have enclosed minutes which we held a coordination meeting, sir, in which all the CEOs of the DISCOMs were also present. They are also taken on board, sir, and they are also equally keen to address the issue, sir. So what we are thinking about, sir, in the next few days to come, we plan to actually ask all the DFOs, specifically, site-specific, sir, to have clear-cut action plans in place. So mostly, sir, this issues of sagging electric lines, bent poles, cabling, etc. has been largely addressed, sir. Enough funds have also been placed. We need to go to the next level, sir, now, in the sense that this DISCOM field staff also, sir, should extend their hand in cooperation. They have assured to do so, sir. We will also have a very close oversight on it. So this is the second aspect on which, sir, we are very keen on. And, sir, the third aspect is that, sir, that of crime. So yes. Yes, sir. Although, sir, the crime aspect was what led to the entire question of elephant deaths coming into prominence, we have now, sir, we have figured out that people responsible for it earlier are sort of lying low. We have, sir, come out with, we have clearly identified hotspots, locations where there are habitual offenders. We have also even earmarked a few people also, sir. And with the with our own, now that the police department is already, sir, well invested into the JTF, sir, we'll be very sure that in the next, we already started making breakthrough, sir, in the sense that even the last few cases, every single case, sir, we have been able to sort of come to at least the backward linkages. We have come to the person who has actually done it, sir. But habitual offenders, sir, we will be just, sir, please, sir.
We'll have to fix timelines for filing of completion of investigation, filing of charge sheets, commencement of trial. I mean, these, we'll have to put timelines for these things.
Yes, sir.
And case-wise.
Case-wise.
Even if there are, let's assume there are 8 named accused, because, I mean, this is known to law people, but you may not be fully aware. Even if you've got 4 of the accused, you can separate the trial and proceed with the trial against the 4 you have behind bars, because you don't have to wait till all of them are apprehended for the trial to commence.
Noted.
Right.
We will work on it, sir. So the apprehension of or the apprehending the offenders as well as arresting the habitual offenders is something very high on our radar.
And proceeding with the trial, I think that's very important, sir, because we're not seeing some real action as far as that is concerned.
Sir, noted, sir. We will.
And if you need to engage special prosecutors, please do that. I'm sure the state government is empowering you in all ways. So if you find that you need special prosecutors, please ask for it and get it.
Sure, sir. We'll do, sir.
Because the real proof of all of this working is to see the action happening.
Yes, sir.
Yes.
So, sir, the crime is one, sir, which we will be working on. And, sir, although the December deadline is a fairly stiff one, sir, but I'm sure with the guidance and cooperation of stalwarts like Dr. Sukumar and other people across the country, including people from Wildlife Institute of India and so on, we managed to come out with a very crisp but very actionable, field-oriented sort of an action plan, sir, which will also... Your Lordship, am I?
Yes. Please go ahead. Yes, please. I think right now there's some problem in the connection.
There is some disruption, I think.
Yeah. I think the image is frozen, right? You can ask them to reconnect.
Reconnect karantu authore, reconnect. Or switch off your video.
Because sometimes hang Delhi clear.
Sir, in the meantime, sir.
No, 1 minute. Kindly wait.
Yes.
Yes, Mr. Nair. No, there is some problem in the connection, I think, because maybe you want to come on audio and can switch off the video, maybe.
Mobile.
If that will help.
Over mobile.
Yes.
Like
phone loge wait speaker
I can connect on phone
mobile.
and there'll be
Yeah.
Speaker delivery.
Yeah, you can just keep near your mic.
Mr. Nayak can speak.
You can speak now.
Mobile volume come.
Hello. Kuantu.
Sir, am I audible, sir?
Yes, you are audible.
Okay, sir, thank you, sir. There is some disruption in terms of connectivity, sir. So, sir, continuing on with our activity, sir, actually, we will try our level best to incorporate all the best practices from other states also. And at the same time, simultaneously get all the field formations that we are supposed to work out strategies, site-specific strategies. And also, sir, look at timeline-based case disposal, sir. So we'll have specifically, the police department is also there with us, sir. So now we will get on to it with renewed focus and ensure that prosecution also takes place at a fast as well as timely manner.
Yeah, Mr. Nair, I think you heard Mr. Sukumar. Mr. Nair, you must have heard Mr. Sukumar, who just spoke before you did.
Sorry, sir, you're not audible, sir?
Because
I think you can.
Yes. Lordship is asking that you've heard Mr. Sukumar. So,
No, I just wanted to flag 2 or 3 concerns that he had. One was this mapping of the corridors. He says that earlier mapping has not been correctly done and it's not even realistic. So I hope you're paying attention to that one aspect of correctly mapping the elephant corridors. That's very essential, sir.
mapping on corridors. What is your comment on mapping of corridors? Because Mr. Sukumar.
Mapping of corridors. Yes.
That's
Yes. So regarding mapping of corridors, that's definitely one part of connectivity, and corridors is one part of the action plan, and we'll certainly be looking at it.
All right. The second is that he was referring to the earlier action plans that central government had drawn up as a task force, and Karnataka, where he was associated. If they can ask for copies of those and look at them.
The action plan of Karnataka and the central action plan that Mr. Sukumar had prepared, if we can get it and incorporate in our task.
Yes, we'll surely do. Dr. Sukumar has already shared the relevant copies, both of the North Central Landscape Plan as well as the Karnataka Plan, and we incorporate both best practices of both of them. Please kindly apprise your lordship accordingly.
All right. All right. The third is, I mean, this is completely outside. I don't know if I'm correctly in assuming this, because of the experience in Tamil Nadu, Karnataka and Assam, and even Rajaji National Park. They planned the railway network in Orissa. And there has been a whole history of elephants being, hit by railway engines and rail trains. And we should anticipate that as far as Orissa is concerned, because they're expanding the railway network. If you can just tell him that.
With regard to expansion of the railway network, okay, because that has been something that has happened in Assam and other states. What is our view on that, on the expansion of railway?
Avoiding elephant deaths due to accidents.
Due to the
rail accidents,
railway tracks accidents.
So, hello.
Yeah, you can speak now. You're you're connected now. You can speak. Yeah.
Okay.
It's okay. It's okay. It's okay.
No, he's connected. He's connected.
Connected.
Yes. Yes. Now you're on. Now you're on. Yes, Mr. Nair.
Okay, sir. Sir, regarding yes. So sorry, sir, for some decision, sir. But as far as sir, from what I could, the conversation was a bit garbled, sir. From what I could make out, we were talking about avoiding accidents due to increasing railway network and so on, sir. If I got it correctly, so that is also that's also one of the points. Yes, sir. Yes. So we have one chapter, sir, looking on linear infrastructure and their mitigation also, and we'll try our best, sir, to not only address, identify very specific locations and try to mitigate it, sir. The ongoing plans, almost all of them have mitigative measures in place, and the government does accordingly give funds for it also, sir. But we will also, after getting inputs from the field formations, like especially from the DFOs, we will definitely ensure that all possible mitigation measures and appropriate locations will also be put in place.
The other thing was, you see, in certain other states, I think they have some scheme of compensation to, deal with the losses suffered by people, whether it's human loss, injury, crop loss, destruction of even houses, vegetation. Do you have any comprehensive compensation scheme for these things?
Your Lordship, yes, Your Lordship, we do have a comprehensive scheme for compassionate payment for depression due to wild animals, sir. And that also includes human kill, human permanent injury, temporary injury, injury for livestock, house damage, crop damage, both for cash crops.
So how soon? See, one is that you have a scheme. The other is that people actually get the benefit of the scheme. So sometimes there is a gap there. Sometimes we bureaucratize it so much that, somebody applies for it and it is not granted for 2 years, 3 years. When it's needed most, it's not available. So we need to look into that too.
Surely, sir, surely. In fact, sir, our compensation payment mechanisms are quite good, sir, but also specifically address any bottlenecks if there are any. We have put in place an app, sir, which has got good feedback from the field, sir. It's called Anukamba, and we will look at all the bottlenecks is involved in that also, sir. But have a scheme in place, several schemes in place, Your Lordship.
All right. Just stay on board because the lawyers will now want to speak, so you can listen to them too. Yes.
May I please, my lord?
Yes.
Sure. My lord, my prayer before the I filed an IA, my lord. So far,
where is that IA? What is the number?
No, my lord, just I filed. I have not. There is not numbered, my lord. And I have this task force, my lord. Actually, they have included 17 persons, my lord, including chairman, and 6 persons from the forest department, 6 persons from the police, and 2 wardens. Only 3 persons, they are the outsiders. And they are the NGOs, those who are get funds from the forest department, my lord. Those who are actually working in the grounds, my lord.
No, we're not going to take this kind of
this is highly embarrassing.
Not embarrassing. They must be included.
We are not.
Mr. Mishra, I'm sorry. You've been listening to all of this. Such serious work is going on, and some really serious points have come. I'm a bit surprised that even without even seeing who the experts are and what they're saying, you filed an application like this.
But those who are working,
I'm sorry to say this. I'm sorry.
Those who are working on the ground, they are not.
Watch. If you're going to be like this, then we will just convert it into a suo motu petition. Because you're not helping the cause, Mr. Mishra. You're working at cross purposes. Remember, this is a public interest litigation.
Yes,
yes. If we get a whiff that you're not actually acting in public interest, we will not hesitate to say you will have nothing to do with this petition. We can do it suo motu. We are giving this indulgence because we think the cause is an important cause. But if we find you are not acting in public interest, we will make sure you do not participate. That's a risk you undertake. I'm very serious about this.
But persons,
yes, please don't work at cross purposes. Please don't work at cross purposes. Remember, this is public interest, and you have to work in public interest. Yes.
So may I be permitted?
Yes.
So myself, Puravi Patra, I am the intervener.
Just give this back. Give this back. We're not entertaining this. Give this back.
Myself, yes. Puravi Patra, I am the intervener.
Yes.
I am an animal rights activist.
Yes.
I want to put few of my points.
Yes.
In the month of June, when few excavations happened, like the elephant skeletons has been excavated in Atagad. So I was an eyewitness over there. So my concern is when STF crime branch was there to excavate the thing, my concern is why after being informed about everything, STF crime branch has not taken any kind of action, like why they have not registered the case. Instead, they gave this case to forest department who were actually in the accused part, because the conciliation and the...
Madam, can I just tell you
the cover up? Yeah.
Because you have to understand how things work.
Yes.
The entire forest department. All right.
Sir, I understand that.
So please, so there has to be some process in place, right? There is a process.
So I have few information that way I want to share.
So what we can do is, whatever information you have, you please meet the JTF and share it with either Mr. Panda or Mr. Nair. All right. We'll permit you to do that.
Yes.
Sir, one more thing. In month of June, during regarding this cover-up cases, when SIT was formed, which was supposed to give the report by July.
We've all gone through that.
Sir, what is happening? Actually, I'm very sorry to say, sir, we are being in the ground level activist. We know that all the time these committees are being formed, and ultimately we are only given with the guidelines and action plans. But in the ground reality, nothing such happening, because I have personally worked with people who are actually involved very ground root level and who are the PSD.
See, there are 2 approaches in all these PILs.
Sir,
1 minute, just listen to me.
Yes, sir.
One is to be cynical and say nothing will work in our country. Anything done is all useless. It has not worked in the past. It will not work in the future. And let's do nothing about it. I'm sure you do not want that.
No, not at all. That's why.
Are you cynical, or are you expecting something positive out of this?
I have definitely
So let us go with a positive approach. Many people have got together. Let us see if what they are proposing works or not works. This is not one final judgment that today we pronounce an order and we will never deal with this matter hereafter. You should know how the PILs work. We have something called what is called a continuing mandamus, which means we keep monitoring it. I don't know whether you've been following this hearing from day one. Are we monitoring it or we are not monitoring it?
Yes, sir.
You are doing it?
Yes.
No. Who is monitoring the matter?
Court. Yeah.
So if you have a positive outlook, if you think something will come out of it, fine. If you think no, judges are wasting their time, these experts are all wasting their time, nothing is going to come of it, nothing happened in the past, nothing will happen in the future, then there's nothing we can say to that.
Yes. So why I said this, because something came to my mind, because people, those who are actually, as I said, who have experience and who are actually the intelligence in those cover-up cases, those who have collected the intelligence, despite the department know it, they didn't involve them in the
whatever you have. If you have the names of those persons, please share it with Mr. Nair, share it with the JTF, let them look into it.
Actually, I guess we have already done it, sir, before. During SIT, we have already spoke.
This is the JTF which is now set up. This is not the SIT.
Yeah. Even
Madam, the options are before you. If you want to be cynical, if you say nothing is going to come of all this, I will not share anything more with anyone, I've already done this in the past, then I'm sorry, then there's nothing we can do to help you.
So
if we have set up a mechanism, if you don't want to engage with that mechanism, then there's nothing we can do about it.
What I want to say, sir, there is a conflict of interest. That's where something is categorically being ignored. So that is the thing I want.
You see, these kind of broad sweeping things don't help us. As two judges, when you told us conflict of interest, neither of us understood what is the conflict of interest. Conflict of interest between whom and what?
If I'm allowed to say, then
of course we're
yes. So the thing is, when there are two people who are actually involved in the intelligence, they collected intelligence and they know
who's the two people.
Sir, I will take one name, Mr. Subhendu Malik, who was there in the Athagad. He's the honorary wildlife warden. He was the intelligence of those cover-up cases. And
what is this cover-up cases? What is meaning of cover-up cases?
Covering up means the excavation cases, the skeletons were excavated by the department and those elephant deaths were not being recorded.
Okay.
That was categorically done by the forest department. That is, we are calling the cover-up because they are covering up this deaths.
Okay.
So these intelligence are done by Mr. Subhendu Malik, who is the honorary wildlife warden of Khurda.
All right.
So despite of knowing this, when SIT was formed for investigating those covering up cases, Subhendu Malik was neither questioned or not called for anything.
All right.
He is having some information which was never asked.
All right.
So when we asked...
So is he still in service, Mr. Subhendu Malik? He's in service. He's in service.
Another month, you take the time.
So Mr. Subhendu Malik should be asked.
Yes.
All right. Next.
One more thing is Mr. Vishwajit Mahanti, who is a PhD in wildlife crime. I respect the members of JTF who are exceptionally, tremendously working on wildlife. But when it comes to, sir, Odisha's wildlife crime and anti-poaching things, Mr. Vishwajit Mahanti is having a PhD. But I'm afraid and I'm surprised why he is not being involved.
Don't worry, then we'll ask them to talk to him.
That is my only concern.
All right. All right.
Thank you.
See, I would only request you one thing. If you start off with cynicism, nothing will, it's all useless, then it will go in a certain direction. If you want to engage positively, there are many ways of engaging positively.
Yes.
All right. I would request you to adopt the latter approach.
Sure.
That's a more constructive approach. It will help causes.
Sure. Thank you.
A lot of humble request is that more people must be added.
Sir, without knowing how this whole team is going to work, don't make these kind of suggestions. Mr. Mishra, I'm not sorry to tell you this. Neither of us will claim to be experts. At least we have the humility to realize we are not experts. But if you presume that you are going to be the best expert over all these 17, 18 people, then best of luck to you. We must learn to be humble, do our homework, find out what is happening. Who are the experts? There's one Dr. Sukumar here. Are you a better expert than him, sir?
No.
I'm sorry to say this. You're tempting us to say these things to you. You have not understood what we have told you earlier, and you're persisting in saying the same thing. I'm seriously thinking, I think we should just dissociate you. We're seriously thinking of dissociating you. You have not understood anything here. Right from day one, I've been finding this, you're working at cross purposes. I'm sorry to say this.
No.
Yes. I'm sorry to, and don't invite us to say something more. Yes.
May I please, Your Lordships?
Yes.
I wish to draw Your Lordship's attention to certain issues which are handled by the in the affidavit,
yes,
which satisfies Your Lordship's anxiety for protecting the man in the man-animal conflict.
Correct.
So we express our, at least I express my gratitude.
Not yet. Don't. Again, let's wait and see.
Yeah.
See, the point really I'm making to all of you is this. Some mechanism has been put in place. Give it some time.
Yes.
Let something work on the ground. If it doesn't work, we're all here. It's not that two of us will just go to sleep and forget about this matter, please. I don't know if you've watched these proceedings from day one. I don't know how you can presume that the judges are not interested in this matter.
Because of nobody can say.
No, I'm just saying, the whole submission seems to be somehow the court is not concerned, only the lawyers are concerned, and if the lawyers don't do anything, everything will go for a toss.
Lord, whatever, because of the kind indulgence of this honorable court, this development, all JTA information, they should understand it because of this
give it some time. Things can't happen overnight. It can't happen overnight, sir.
And we are responding all the directions of the honorable court in true letter and spirit.
And let me request this. This is, in fact, PIL is called non-adversarial because we all work collectively. Right? We put our heads together and find out best solutions.
Yes.
Nobody, neither the JTF, nor Mr. Monty, nor us, nor you should presume that we have all the answers to the problem. Maybe some of us have some elements of the answer and not the whole answer. So let's work together and let's try and make this work.
It's an interesting aspect where they're saying that they'll involve the Sarpanch and the PRI members.
They should see, ultimately, if the people are not involved, it will simply not work.
Yes, Mr. Jita Satru Mohanty, I think he's on board. His suggestions in the affidavit focus on the man in the man-animal conflict. So that is where Your Lordship.
So, Mr. Nair, what I'm going to ask is, what is your name, madam?
Puravi Patra.
Miss Puravi Patra is here. Is he there, Mr. Nair?
Are you hearing, Mr. Nair?
Again, it's frozen.
Mr. Nair.
I think it's not.
Sunuchanti?
Yes, sir. Yes, I'm hearing Your Lordship.
Puravi Patra will probably seek time from you. Please give her a time to meet. And she has certain concerns. Let her place them before you. And she's mentioned two names, one Mr. Subhendu Malik and one Dr. Bishwajit Mohanty. If they can also be consulted by the JTF. I don't know.
Yes.
All right.
Yes.
Okay.
I'm listening, sir. Yes, noted, sir.
All right. See, the court has had the benefit of participation online by Dr. Sukumar.
Mr. Raman Sukumar.
Dr. Raman Sukumar, who's an expert is a wildlife expert with specialization in elephant movement, issues concerning elephants, and has vast work experience in several states in the country on the issue. It has also had the benefit of the participation in today's hearing online by the Joint Task Force, which has been set up. And the court was addressed by Mr. Manoj Nair, the Principal Chief Conservator of Forests.
CCF.
Chief Conservator of Forests.
Chief Conservator of Forests.
Wildlife.
Full stop. The court has also been addressed by the counsel appearing for the various parties and Ms. Puravi Patra, the intervener. Full stop. Paragraph. The court has also produced the affidavits filed on 10th November 2022. So the affidavit on 10th November 2022 by the chairman convener of the Joint Task Force, as well as the additional superintendent of police, who's a member of the JTF.
And on the same date, we have also filed another affidavit.
Yeah, two affidavits. That's
Yes.
what, right. I've said a copy of the draft framework of the comprehensive action plan has been enclosed with the affidavit of the chairman of the JTF. Mr. Nair informs the court that the attempt is to roll out the action plan and achieve some of its targets by the end of December 2022. Paragraph. Among the issues highlighted by Dr. Sukumar was the proper mapping of elephant corridors in Orissa, which have not been scientifically done. Full stop. Mr. Nair assured the court that this will be one of the issues taken up by the JTF and will be addressed in consultation with the experts in the field, including Dr. Sukumar. Full stop. The other, full stop, he further added that the JTF will examine the action plan that was put in place in the state of Karnataka while dealing with a similar issue, as well as the central north corridor, is it, action plan?
Sir, it's the East Central India Elephant Action Plan.
East Central India, as well as the East Central India Elephant Action Plan. Paragraph. Mr. Nair also said that the JTF will be addressing the issues of involving the local populations and finding ways of their participation in working out many of the elements of the comprehensive action plan. Stop. According to him, the electricity distribution companies have already been consulted to address the issue of elephant deaths on account of electrocution, which has been happening in great frequency. Full stop. On the issue of elephant poaching, he assured that concrete action would be taken to take the criminal cases to the logical end by having timelines for completion of investigation, filing of charge sheets, and then pursuing the trial till its completion. Full stop. The court expects that a more detailed, granular action plan on each of these aspects, giving timelines, specific timelines, will be placed before the court on the next date. The court has impressed upon the JTF that they should address two other issues. One being the preventive measures to avoid rail accident deaths of elephants and a comprehensive compensation scheme to address the human loss and injuries suffered as a result of man-animal conflict, as well as crop and vegetation. Full stop. If Mr. Nair pointed out that there is already a scheme in place, full stop. On the next day, the JTF will explain the timelines for disposing of claims for compensation under the scheme and what amounts have been disbursed thus far. Paragraph. Mr. Nair has taken on board the suggestion of Ms. Purvi Patra that the JTF will consult Mr. Subhendu Malik, who is the
Honorary Wildlife Warden Khurda.
Honorary Wildlife Warden Khurda, and Dr. Bishwajit Mahanti, who's a wildlife expert.
Yes.
All right. We'll stop. When should we have this?
It's in January.
January.
Because by that time,
And
the comprehensive action plan also.
Provision December with the complete.
We'll have it on 18th January.
Obliged.
Mr. Mishra, don't take it amiss. It is all in your interest. It's only in. All right.
Obliged, my lord. Deeply obliged.
I hope you'll take it in the right spirit.
My lord.
All right. All right.
Obliged.
Deeply obliged. All right. This one. Yes, yes. Ask him.
Item number 89, sir.
We have taken off our PIL hat. No. Come back to this.
Remembering one thing, Lordship, disruption used to go by matador. While going by matador, it goes very smoothly. All of a sudden, in the middle, it stopped. Then you have to get down and give a push. Then it started boo boo boo. And this interruption of this video conferencing and all these things become rampant.
Yes. So you want to cite a Supreme Court judgment?
And few facts.
Facts have gone past, sir. We are now in the stage of Supreme Court judgment.
Let it come tomorrow. It will take only 15 minutes because I have got another 2-3 judgments during this
Next,
time.
come to your next point. This point is already heard and rejected.
Let's say because once my lord say rejected.
No, that point is rejected. Not the petition is not yet rejected.
Let's let it come tomorrow.
No.
Because all of a sudden this matter came.
It's all right. We've spent a lot of time. Carry on.
Because some judgments I seeing them in the net, but thing is hard copy need to be.
It's all right.
Kindly bear with me for tomorrow.
We're unable to help you, sir. Sorry. Carry on.
Because I'll not be get satisfaction.
We cannot help that, sir. We cannot help that.
Let's say what my prayer lordships initially, let's say kindly come to page 58.
Yes.
Page 58.
Yes.
And thereafter page 64. Lordship.
Yes.
What is my prayer basis, lordship?
Right.
My basis is 8/6/2006, lordship.
Yes.
This project wing HIW wrote letter for release of security deposit. Lordship, with reference to letter cited above, copy of the order said release of security deposit against different job executed. Lordship, there is no dispute that I am not entitled This is their calculation.
Yes.
This is the calculation of the authority.
Right.
Writing to another authority to release. This is finance. Deputy Director of Finance wrote letter to release. In this footing, Lordship, going back for an alternative remedy, I am cutting in both ways, my lord. One way is, Lordship, during my claim, it is subsisting and a letter has been issued. Thereafter, disinvestment made. And in that disinvestment, they did not consider my aspect, Lordship. One aspect, Lordship. Second thing, Lordship, I am willing to cite judgment, Lordship. This is High Court of Andhra Pradesh, Lordship, by Honorable Justice A.R. Lakshman Chije and Golu. Civil maintainability of writ, Article 226 of the Constitution of India. Final bill of the petitioner not settled by respondent even long after completion of contract for appropriate order. Question of maintainability of writ raised. Writ maintainable against inaction on the part of the respondent. Respondent here is the government. Then, Lordship, my access to justice, Lordship. This is a situation, Lordship, kindly consider. Nowhere it is disputed that I am not entitled. Now my whole company is closed, going here and there. In spite of I have got an order by this Honorable Court. We have direction, Lordship, by this Honorable Court, go and approach for release of money, Lordship. When I went to the Bhubaneswar, I found HIW has been disinvested. This is the Honorable High Court order, Lordship. I have shown, my lord, the order passed by this Honorable High Court in Division Bench.
You already read it, sir.
So, in this eventuality, Lordship, it's a government, IDCO, who has taken all the money, and IDCO is liable to make the payment of that money. Because there is no dispute any point of time or anywhere regarding my EMD. If there had been a dispute, I could have certainly gone for other alternative remedy.
That's it, sir.
Another 2-3 judgments.
Muhammad, please carry on. Carry on.
This one aspect, Lordship, 278 SCC. This is Lordship's stakeholders. Stakeholder is here is the government. Lordship, in that eventuality, there is no dispute in not releasing the money. Therefore, it is maintainable. Then let's see, JT 2009 6 SCC 263. This is very interesting, Lordship. It was in this judgment, Pradeep Kumar Biswas case was taken care of by the Honorable Supreme Court. In this, Lordship, share capital and functional and administrative control with the state government. Calculated amount has to be paid, Lordship. Because what I am hampering, Lordship, hampering against the state under Article 12, writ is maintainable. Second position, I am having, Lordship, this is, Lordship, reported in AR 1992 SC 76. This is regarding milk product and all this dispute, Lordship. Honorable Supreme Court says, since it is managed and directed by the government and appointing authority has been name has been recommended by the government, therefore government is liable to pay. Writ is maintainable. Now, in this juncture, Lordship, I ask myself a question, where I'll go. Whether an injustice has been inflicted to my client. Lordship, 2000 till now, I am moving here and there. Who is to pay me? I have done the work, everything is done, who is to pay me? Now HIW is closed. ITCO says, no, you go to HIW. Lordship, if that aspect is taken into consideration, I am certainly entitled to get the benefit under Article 226. In that aspect, I would like to say this Madras High Court judgment, Lordship, this is Madhura and Thakam Agricultural Producer Cooperative Marketing Society and others, Lordship, mental ability of reddict. Maintainability of the rate person, it was held that it will maintain.
No grounds made out for review petitions dismissed. Just call out in passive matters. Made. My lord, this is the case.
Lordship, only I would add, Lordship, one more thing. In this case, there is no alternative efficacious remedy available for me.
All right. Made, Puja. It's a case, the appellant in the Union of India has challenged the order of the Honorable Single Judge, which was passed on 17/1/2019, and it was listed, my lord is pleased to issue notice and pass interim protection in past in your favor. If the sole point is that my Honorable Single Judge has passed an order in that judgment saying that the petitioner who is before my lord, who is the opposite respondent in this case, with the petitioner before my lord at a time filing writ petition, he was not working in the month of March 1993, and he was, after March, he was relieved from that place. So question of committing fraud does not arise in his case. But fact remains that out of 2 lakh some odd corruption, 70,000 some odd has been committed, corruption has been made in during his period. That is on the month of February 1993, not after March 2023. That is page 90 of the writ petition. I am sorry, my lord, this earlier previous council filed this appeal without all these records. Let's make the writ petition copy might have my lord's page 90, let's see, may see. Yes.
This running page 90, internal page 57.
Yes.
Page 90. May I read, my lord?
Yes, please.
On thorough verification of the each, that is TADA bills sanctioned during financial year 1992-93.
Yes.
On thorough verification of each TADA bills and paid accountants rules for the above financial year, it is observed that the same are in order. However, bills number such as dated 23/2/1993 is very important, my lord. 23/2/1993 for 70,724 is the matter of bill of repetition of the bills such and such dated 10/1993 up to 2000. That means this period bill was sanctioned, he was very much posted there. Even though it was sanctioned in 10/5/93. My lord, the single judge erroneously takes the date that 10/5/93 instead of 23/2/93. The only first point is this, my lord. Second point is this. There's one observation taken that the two witnesses will declare hostile. The prosecution, because in the time of proceeding the case, the two witnesses have been hostile. That is, all are accused. Here is the 6 persons are being accused. Those 2 persons were hostile by the prosecution, disbelieving their own witness. That they are also accused in this case. They have filed a writ petition before the different high courts, and it was also dismissed. And one is in our high court, another is in Delhi High Court, another is in Bombay High Court. Then, my lord, this third point is that he has acquitted on a benefit of doubt, not honorably. This honorable apex court has decided on present Chief Justice of India is on the earlier passed an order. Recently, was Chandrachud's judgment, Justice Chandrachud's judgment, that is reported in 2022. That is one is SLP number 24095/2019. In that case, I'm just passing the my lord. I will give a Xerox copy of the same. Already it was submitted court, my lord. We have Xerox copy. And in that paragraph 7, let's see. Another judgment we have, it is State of Rajasthan versus Himsing region 29 October 2022. This paragraph 37 and 39 both are very relevant, my lord. And paragraph, I am just reviewing paragraph. As you have already indicated, in the absence of any provision of the service resettlement, if employee is honorably acquitted by the criminal court, no right to confusion on the employee's will. Here is a case, he was acquitted on benefit doubt. In that venture, he cannot be exonerated from the charge made by the Department of Inquiry in this regard. Then, my lord, I am also citing another judgment of SLP number 24095/2019. Sorry. That is civil appeal number 1763 and 1764 of 2022. In that para 17, in exercise of judicial review, the court does not act as an appellate forum over the finding of the disciplinary authority. The court does not replicate the evidence of the basis on which the finding of misconduct has been arrived at the course of disciplinary inquiry. The court exercise the judicial review must restrict in the review of determine the Well, let's see, the last judgment I've started upon, that is 22nd March 2022, pronounced by the Honorable Justice D.Y. Chandrachud as well as the Suryakant. In that, paragraph 17 is very much important. I will already filed this same before my Lord for prevision. So, in this conjecture, the observation, Lordship got it?
Yes.
In this conjecture, my Lord, the judgment passed by Honorable Single Judge cannot be certain in the eye of law, and the specific environment they have taken, Lordship may count. Now I am committing the judgment, my Lord. This is running page 29.
Yes.
May I read, my Lord?
Yes,
page 29. The inquiry officer found that the charge number 1 is proved on 17/6/19. After 3-4 lines, I am just studying here.
Yes.
On 17/6/1998, the inquiry report was submitted holding that the charge number 1 is proved and charge number 2 is not proved. To such inquiry report that at 17/6/1998, the petitioner submitted repetition on 8/7/2019, specifically mentioning that since the SI BP Bhandari was not examined in the disciplinary proceeding, his statement recorded in the preliminary inquiry cannot be unutilized as per the CISF circular number such and such. Furthermore, after March 1993, this is important. Furthermore, after March 1993, was posted at non-government fund sanction, which has no nexus with the account section. And the alleged indicated took place after March 1993, and as such, the petition is in no way connected with the incident took place after he was relieved from the account section. Here is the case, he was relieved in March, but the occurrence took place in February 1993. So the observation made by the Honorable Singhijas cannot be sustained in the law because during he was working in that period, the fraud has been committed. Out of 2 lakh something, he has 70,000 something. That was reflected in the page 90 itself. Other grounds we have taken, my Lord, I have submitted this out as papers. All right.
Wait, please, my Lord. My Lord, in so far as the disciplinary proceeding is concerned, I have challenged the disciplinary proceeding on 2 grounds, my Lord. First ground, before initiation of this disciplinary proceeding, a preliminary inquiry was conducted. In that preliminary inquiry, my Lord, 2 persons, the co-accused persons were examined, and they have given their statements in the preliminary inquiry. Basing upon that statement, my Lord, the regular disciplinary proceeding was initiated. In that regular disciplinary proceeding, the person's statements were relied upon. He was examined by the departmental inquiry authority. Since his statement was not in conformity with the preliminary inquiry, that person was declared hostile. But so far as the second person is concerned, he was never examined in the regular disciplinary proceeding. What happened, my Lord? When the petitioner wants, this present respondent wants to examine that person, they have rather relied upon the preliminary inquiry report and the statements relied there, taken thereon. My Lord, they have not relied upon the statement given in the disciplinary proceeding, my Lord. On that ground, the petitioner has been found guilty. That has been reflected in paragraph 6 of the impugned order, my Lord. And the second ground is, my Lord, so far as this tampering of that TA bill and so on so is concerned, the specific case of the present respondent before the disciplinary authority is that this is not my signature. And if this is my signature, let it be handed over to the handwriting expert. That has been denied by the disciplinary authority. On the ground that preponderance of probability is the main basis for come to a conclusion that is not necessary. On 2 grounds, this writ petition has been allowed, my Lord. First, the opportunity has not been given to cross-examine the persons whose statements has been relied upon by the disciplinary authority. Even though that report is not in the present disciplinary authority report, that is the fact-finding inquiry, which should not be relied upon unless an opportunity should have been given to the delinquent officer. On that ground, this writ petition has been allowed now.
All right. All right. Anything more, sir?
One point I am clarifying. A persecution creating hostile. The prosecution agency who is prosecuted against him is one agency. Then with the department official, CSF is proceeding on the department inquiry, is another organization. So even though a person who was hostile by the prosecutor, disbelieving the witness, because in the time, because he's another accused. Out of 6 accused, he is one of the accused in this case, and he has filed the petition, he is dismissed. So their statement cannot be relied upon for proceeding of the case, or basing on which he cannot be a ground for exonerated from all the charges.
No. I think the point he's making is in the preliminary inquiry,
yes,
2 people spoke.
Yes.
You're relying on statement of one of them.
Yes.
But not offering that person for cross-examination.
No, my lord. Out of 6 accused persons, the same are being witnessed in this case. Here is the peculiarity of the case there.
No, but in the disciplinary inquiry, he has a right to cross-examine a witness who's speaking against him, please.
Oh, they have given. That was there. That was what differing. It is not that the prosecution, who are the witnesses before the prosecution, they are not the witnesses before us. Whoever the witnesses, they have prosecuted, they are examined before the disciplinary authority.
Anyway, we'll see that. All right. Orders reserved.
Obligation.
Right.
Item number 19.
Obligation.
My lord, I compelled to file this review petition because this judgment pronounced by this honorable court on dated 30th. On 30th July 2008. It's like 2010. Sorry, 30th July 2010.
Yes.
So in that order, that operative para was not matching with other para. That operative para is according to our grievance, and the other para is negative to our grievance. For that only I filed the review petition for having judgment.
It's all right, sir. Did you submit an application or you did not?
Yes. Then I'm not submitted because they have it will be different type of letters. You do that according to my inside pages, the contents of the inside pages, they acted differently. But this operative para, it is our in favor. It is in our grievance, under the grievance. But the people they are asking in different way for acting under their things. So that has happened, and that is that was pending. And also I have submitted the copy to all the opposite parties. Subsequently, they issued a notice under section 29 for complying their demands. So I said, since the matter has been referred to the High Court again for adjudication, so you have to wait, let the decision come. If you want any persuasion, then you can pursue the things before the court. Then they suddenly came with a police force on 5th February 2011. You vacate the premises because we have the power and we have the right to take over the things. I said it is since with the court and the operation part was the operative. This para was in our favor. Let us wait for the decision of the honorable court. They didn't listen. Then I filed an application before this court under the WPCRL, and it was taken up by the Chief Justice court, and notice was issued, and a lot of things have taken up by the honorable court. The things have been details have been filed in our IA number 156 2018. So it will be available. My lordship can, if you go through the detail, then you will find all the facts and details are available there. And subsequently, they have. I came to know that they have sold all my property to a auction purchaser, and the auction purchaser was also informed under this court order, but that auction purchaser took different different tactics. This applying under the provision of the writ, and he obtained the order without informing us, without taking the court decision, and things has been taken up by themselves according to their own wish. My lord, this has happened, and we have been suffering since 20 years, because our initial challenge was with the bank for sanctioning loan amount in accordance with the Reserve Bank guidelines. Reserve Bank guidelines, and that was to. I have been requesting them since long, and it was not being cooperated. And finally, court passed order in our favor. Though it was passed order in our favor, but things was taken up in different way. And I hope this has been some malpractice has been taken by under this judgment, and according to they have taken over all the things of our including personal things also. My lord, all these things I have quoted in my IA number 156 2018. And my wife also, when she came to know about the things, and she became shocked, and she suffered brain stroke.
Okay. We'll reserve orders. Orders reserved, sir. All right.
Thank you.
This one. What's he saying? I don't know. Mr. Mishra, we are reserving orders. You have to unmute yourself.
Yes, my lord. I was appearing in the read petition. Here, no notice has been given.
Yeah. Just reserving orders. All right.
Item number 47.
Lordship, here the revenue challenged the order of the ITAT. On the ground, your Lordship, see the last page of the tribunal's order. Tribunal has remanded the matter, and the assessee is accepted, but the tribunal has restricted one part and remand for the rest of the issues.
It's all right, sir.
And the 263 proceeding also, my lord, if your lordship see, page 23, the amount may please, the AO is directed to make assessment de novo after due examination all the issues mentioned in the so-called notice, other than the issue discharge expenditure shown to be under section 40 AI, as those who need to factual verification by AO in light of submission made by the AO. The AO also directed to make proper inquiry necessary in this case, giving assess opportunity hearing. However, while making de novo assessment, they was directed to add the amount shown amount. So that part has been restricted by the tribunal remand. Therefore, my lord, the question number 3, if subject to a lordship, I may frame, lord, if a lordship give it an open remand so that examine all these issues and pass a regime order, I think, my lord, the purpose will serve in all the parties, my lord. Therefore, my lord, if a lordship admit question number 3 and issue notice and can dispose one day. Because Tribunal is either in part.
It's all right.
Yes, blood. CIT is blood directed to de novo assessment.
No.
Directed to
CIT already allowed the expenditure 134 under 40A1.
Yes.
And you did not appeal against that.
No, no, Your Lordship, I may be. Your Lordship, kindly see the last page.
That's right. They're only saying that to the extent that the SSC has appealed, they're remanding it only on those issues that the SSC has appealed against. Those have gone back to the AO.
Yes.
But where you have not appealed against, why should they send that to the SSC? AO. They need not send that to the AO.
No, but the tribunal says, my Lord, if I'm not correct, my Lord, page 30, Your Lordship.
Yes.
I may be, my Lord, because I am not having the brief.
No.
Therefore, you are in the considered view that the learned directing the assessing officer to resolve the claim of raw material, computing the amount of soon to be added in the hand of the SSC was beyond the jurisdiction of 263 and is directed to be quashed to that extent. However, as the learned counsel of the SSC agreed to re-examine the other issues raised by the learned CIT and direction to the assessing of to denovation, same is upheld. So, two parts, my Lord.
No. So, the disallowing of 1344 was quashed
by the tribunal, my Lord.
So, the SSC succeeded.
Yes, but raised part is not directed. But that is the question raised by the revenue, my Lord.
Yes.
That this is not correct because the issue, Lord, for section 40AI, question number 1. The IT justified holding the condition assuming jurisdiction were not fulfilling impugning issue additional expenditure rupees Way Act and when you had not done in prudent inquiry before only impugning expenditure for which reason order was erroneous as a project interest of the assessing officer does not consider the 40AI while passing the assessment order. Therefore, revisional authority directed to add back that amount in the.
But that was clearly, sir, in a 263, how can you ask amount to be disallowed?
No, but after he has directed for
363, you can only ask for a reopening of the entire assessment. You can't say you better allow or disallow this. So that was beyond his jurisdiction.
No, but he has given the reason. Interest of revenue, so far as the interest of revenue and fiduciary interest that has been clarified. In that fact, Lord, after amendment, Lord, he can issue this issue, Lord. After amendment 263.
Where is that?
Lord, I'm. Let me please.
So what you're saying is let all issues be examined.
Yes, that is what my to solve these issues. Not nobody will agree. Nobody will prejudice to that. Proper examination should be made. By giving a proper opportunity, it can be.
But what is the material for that re-examining of that issue is the question.
That is dealt with by the in para. It starts from page 15. The region which are not in para 2. May please.
Yes.
From the document furnished by the assessing courts of assessment proceeding, it was seen that the payment aggregated rupees stones were made for non-residents pay during the relevant previous year. Though the tax was deducted at source from such payment made under provision of section 995(1) of the Act.
No, but this is imported, no?
Yes, no.
So why should there be any tax deduction at source for imports? In fact, that's what is being pointed out by the...
Later on it was discussed. Later on it was discussed why it was being taxed. The assessor failed to deduct any tax for which the reason of being expenditure was not allowable deduction and so and so. However, he was not considered the imputing amount for difference of completing the assessment. Now, Lordship, see the finding of the...
See, the assessing officer had categorically allowed the claim of 99% of the raw materials purchased being imported raw materials.
Yes, Your Lordship.
Was therefore in accordance with the scheme of business of the SSC and not because the SSC was to determine the nature of payments first.
Lordship, can you see page 17, paragraph 3.6. Sorry, 3.6 is not depreciation and not plea.
Yeah. We'll pass the order. This is not a case we wanted to hear. All right. We'll pass the detailed order. Dismissed. Yes.
No. Item number 78, sir.
After so many extreme sensitive matters.
You have to wear several hats in a day.
Lordship, I had a very heavy board minutes.
I know. But very exciting board.
Revenue matters now will be
hearing Dr. Shiv Kumar was interesting.
Yes. It's so educative, no?
With his vast experience, it was really the first time I saw him in person.
Okay. See, the advantage virtual hearing is this. I keep telling my other colleagues in other high courts.
Interact with the best of people around the world.
Correct. Yes.
But on the last occasion, my lords may kindly remember, your lordship was asking me, I have filed time petition, but I have annexed along with a copy of the writ petition, the computer report. But a physical copy of the time petition was not there. Your lordship couldn't be able to know for how many days I have prayed for time. In the meantime, also, your lordship was also asking me to find out the judgment of other high courts.
Correct.
I have got 6 number of judgments of other high courts.
Okay.
Dealing with identical issues.
Okay.
If your lordship will see, there's only few documents are there. Petition, starting from the notice and culminating with the order passed under 148 AD.
Correct.
So your lordship will find notice under 148 AB was issued by the Annex 11/3/2022.
Correct.
And application for adjournment as per the computer report minutes generated on the portal minutes, that is on 15/3/2022 minutes.
Correct.
Minutes, even though I don't have a copy of the petition, I prayed for 7 days time. There is a communication, I have taken instruction saying that Income Tax Portal allows to file online request for extension of time and removes the button after the time expires. It sends a system generated mail, which is provided in proof. Proof is there, but number of days prayed for is not available.
Right.
But be it 1 day, 7 day, or 10 days, open. It's a reply, admittedly, as per the counter also, they admit I have filed reply on 23/3/2022 minutes.
Correct.
And the order passed under section 143 AD was on 26/3/2022. Your lordship will find from the entire scheme of minutes 148 A minutes, there is a notice period and also there is an order period during which order is to be passed. There's a notice period is not less than 7 days, not more than 30 days, within which an assessor is permitted to file a reply. So filing of reply cannot exceed 30 days. It is within 7 to 30 days. Upper maximum limit is 30 days. I will show to your lordship some judgments dealing with this, saying that even the assessing officer grant adjournment so moto up to 30 days, not beyond. And if prayed for also 30 days. That cannot, because this is the notice period, Milords. And here, Your Lordship, within 19 days, Milords, and order when is passed, when a so-called reply is filed, Milords, order under section 143A(d) shall be passed within 30 days from the date when the notice seeks us to file reply. When the reply is filed, within the end of succeeding month from the end of that day. Your Lordship was asking my friend the other day to reckon filing. Anyway, so that is the ordering period. Let me repeat, 30 days from the end of the month during which reply is filed, or from the date I am asked to file a reply. So therefore, 148A divides itself one noticing period and one ordering period.
Right.
But Your Lordship found on record within 19 days itself, the order is passed without Milords considering the reply, even if it is available on record. So now, Lordship will find, I will bring to Lordship notice judgments. It all says that the whole Milords legislative intent behind 148A, which Milords takes its birth from judgment of the Honorable Apex Court in Milords that drives that Milords. From that only this Parliament went for amendment, and now this 148A sees the light of the day, Milords. And this pre-decisional hearing scheme mechanism, which is put in place in 148A, Milords, that is all intended, Milords, to dispense with, to give away, Milords, to do away with frivolous proceedings, so that only in true cases where there are material giving rise to initiating proceeding under 148, that can be reduced, boils down to those only, not to all others. And for that, this mechanism is put in place. While dealing with this reply and disposing of by passing an order under 143A(d), three things have to be considered. One is 148A(1) speaks of inquiry. Your Lordship will find the opening word shall. The assessing officer shall. Number one, inquiry. He will embark upon an inquiry, Milords, based on information. What is that information? Information is also provided, Milords, it refers to the provision mentioned, that is in section 148, explanation 1. For the purposes of this section and section 148A, the information with the assessing officer which suggests that the income chargeable to tax as escaped assessment means 1. Any information flagged in the case of the assessee for the relevant assessment year in accordance with the risk management strategy formulated by the board from time to time. B. Any final objection raised by the Comptroller Auditor General of India to the effect that assessment in the case of the assessee for the relevant assessment year has not been made in accordance with the provisions of law. And explanation 2 refers to where search is conducted, where survey is conducted, with prior approval, those can also be the basis. So therefore, 148A(d) speaks of three things that have to be taken into consideration before disposing of the application and passing an order, giving rise to issue of notice, either to issue or not to issue. One is the inquiry, outcome of inquiry that he has to consider, 1. Number 2, the so-called reply, which is filed and available on record, 2. And 3 is materials available record. And Your Lordship will find the order is passed on 26/3/2022. On the date when order is passed, the so-called reply was very much available on record. So the three things which are to be conjointly taken into consideration.
No, but if it was not filed within the time prescribed, was he obliged to consider the reply?
My lords, that is what the Honorable Court has taken into consideration and opined also. I will take Your Lordship's attention to those judgments, my lords. Because during the notice period, the whole objective, Your Lordship may kindly see legislative intent. And this is to be appropriately also interpreted.
What's the meaning of that timeline? What is the meaning of that timeline?
No, timeline, my lords, Your Lordship will find, even going by fact also, 7 days time they have granted, not 8, 7 days time. Notice is issued on 7/3. I have been asked to file a reply on 15/3 minutes, on or before 15/3. And on 15/3, it is not that I avoided or I didn't respond. On 15/3, as a matter of fact, I responded, filed an application. And portal report. This is not private.
No, that's right. But that application was not allowed. There's no order allowing that application.
My lords. So on that's my humble, your lordship is aware of. I will be taking your lordship's attention to two judgments. But what is the law on adjournment? Because there is one judgment of Honorable Apex Court and one Honorable Delhi High Court saying precisely, before I take your lordship's attention, judgment saying that adjournment is not a matter of right that you claimed by the petitioner in a proceeding matters. But whenever an adjournment application is filed,
in fact, this question will apply to all of you. So I'm presuming that you're inviting a ruling from us on all these points, which means you will not be able to do this in the assessment proceedings if it goes against you. If we are with you, then there's no problem at all. Then everything goes. If we are not with you, you don't have the opportunity of urging all of this when you challenge in the assessment proceedings.
No. My lords are not with us, and we are gone.
No, you're not gone anywhere. You'll only take a flight to Delhi.
That will not be there, my lords. Let him complete. Let him complete. What is hovering in our mind is the judgment of the Punjab and Haryana High Court endorsed by the Supreme Court. Let my learned senior complete his argument.
Correct. No, but equally it applies to him also.
Beg your pardon?
Even he has to address that.
Yes.
No, which is why I'm asking this question. So in that case, then you will not have, I'm saying you are willing to risk adjudication of all these points which you're arguing at this stage itself.
No. What I am telling your lordship, there are two things.
No, I'm just saying, see, theoretically it's possible that in the reassessment proceedings, they can original assessment and say there's no need to raise any additional demand. All right. In that case, you don't have to challenge anything at all. But if it goes against you, you will not have these points to urge.
No, only
because you would have already invited a judgment at this stage.
That's my whole endeavor, lords, to persuade your lordship is violation of natural justice.
All right. No, I'm saying, no, you have points. We're not saying you don't have points. You've listed out 3 points, maybe you have 10 points, somebody has 15 points. We're not on that. Once we adjudicate all those 10, 15, 20 points here at this stage, if we are not with you,
my lord,
then at the stage of assessment, you will not be able to urge these points to challenge that.
I think there are substantive points which your lordship will fairly also agree with us in some cases.
No, this is just an open whatever exchange.
And one thing, Milord,
we are not anticipating whether we'll agree or disagree at this stage.
But one thing, Milord, regarding that Honorable Apex Court decision, 5 lines decision, Milord, maybe 5 lines, or that is not a thing, Milord. But that will not, Milord, deter your lordship, Milord. Why? The reason being, if your lordship will see 2 lines, Milord, we have been examining.
Yes.
Case, first sentence, there is error. Because the Supreme Court decision, we cannot say so. Your lordship, what is challenged before the High Court? Your lordship is looking at the order. Your lordship kindly.
Yes.
What is challenged before the High Court was the reopening notice under section 148D of the Income Tax Act 1961. In fact, 148D is the order.
No, this is not that.
Not a notice. Anyway, there must be some error, inadvertent.
What is the document?
No, you're reading the Supreme Court order.
Supreme Court, yes.
Where is that? We don't have another copy. You can hand over.
It's not a copy.
I think that is attached, that is attached, with the WPC 14552 of 2022.
1 minute.
It's perhaps the last but one item in your lordship.
14552. We have it here.
That's there. The Honorable Supreme Court's order is there.
All right. Achyuta Nayak.
What is challenged before the High Court was the
1 minute.
Anshul Jain. Anshul, I'm sorry.
Anshul
Jain.
Achyuta Naik?
No. Anshul Jain.
Anshul Jain.
No.
Okay, you read it. You have a copy.
Fine.
What is challenged?
What is challenged before the High Court was the reopening notice under section 148D of the Income Tax in 1961. It should be 148A(b). In fact, D is the order notice, Minos.
So probably what is challenged was the order.
Your Lordship, may pardon me, I'm just passing on.
Not B. Yes.
We have one
Lord.
copy. One
Yes.
is enough. Yeah.
Now, Your Lord, this is very important sentence, Minos. The notices have been issued after considering the objections raised by the petitioner.
This also should be an order.
Minos. Order. Very correct, Minos. So therefore, the word notice is mistaken.
Should be substituted by order.
That is, yes. But here what has happened?
All right.
Because those are the cases which are before the Honorable Apex Court, Minos. Notices are issued, Minos. Objections that are considered, and after consideration of those replies, when the order is challenged, approving the order passed with Honorable Delhi High Court, Honorable Apex Court said, if you have any grievance, then you can approach into 148 proceeding before the assessing authority. So there is no need to entertain now. So, Milords, I have the cases, Milords. This is a case, Milords, where so-called reply notice issued, Milords, so-called reply filed. So-called reply totally oblivious of the reply on record order was passed. He has not considered at all. So that order may not deter your Lordship to proceed ahead with the matter. And what your Lordship is now just a little while before saying, that I am not on this issue that your Lordship will answer the entire. I only have my limited prayer is that I want to go back to the state where I was there, so that he will reconsider, because that is the whole intent for which the provision is there. My prayer is so that the fact will more clearer.
Correct.
Whether in that case objection filed or not filed, whether steps
I think
taken
it's a
or not
standard format order, because 2nd June, all these orders of Punjab and Haryana High Court are 2nd June, including Gyan castings and all that. Several orders seem to have been passed on 2nd June.
Yes. So I'm not taking much into that. Only in that case, Honorable Punjab and Haryana High Court said that petitioner responded to the same. Same means the notice issued by.
What you handed over to us is all the other high courts.
No, that is what I'm taking to. I'm just pointing out this. In Anshul Jain's case, Honorable Delhi High Court said, no, I'm not on that minute. 1 minute. In Anshul Jain's case, as per the judgment of Honorable Punjab and Haryana High Court, notice was issued.
Correct.
So-called reply was filed.
And after considering that reply, the order was passed. Your case, you are saying, since he's not considered the reply and passed an order, this Anshul Jain will not apply.
Yes.
All right.
Now, Milords.
All right.
My Lords, may kindly see judgment of Honorable Delhi High Court.
Divya Capital.
My Lords. In the case of Divya Capital, yes.
Right.
Milords, before I take your Lordship's attention to relevant paragraph, just precisely I am placing the fact, Milords.
Right.
17/3/2022.
Yes.
That is the date on which notice under section 148A(b) was issued to the assessee, Milords.
Right.
On 24/3/2022, Milords.
Yes.
Reply was filed. Milords, in the reply, He sought for reasons, my lords. That reason be given. That was no response from the revenue, my lords.
Correct.
Then second reply was filed on 31/3/2022 with a detailed reply, my lords. And thereafter on 4/4/2022, order under section 148 AD was passed without considering reply. That is the case exactly what has. Now I will take my lord's attention to paragraph 12, my lords. The caption wise honorable court has dealt in. Petitioner was not given reasonable time to file a reply. This court is also view that petitioner assessee has the right to get adequate time in accordance with the act to submit reply. In the present case, the impugned order under 148D of the act has been passed in great haste and in gross violation of principles of natural justice, as the petitioner was not given reasonable time to file a reply. In a matter where on the basis of tax related source, goods and service tax, security transaction tax returns updated by the stock exchange. Keep this. Paragraph 13, sorry. It is pertinent to mention that section 148BAB permits the assessing officer to so moto provide up to 30 days period to an assessee to respond to the so-called notice issued under section 148AB, which period may in fact be further extended upon an application made by the assessee in this behalf, and such period given to the assessee is excluded in computing the period of limitation for issuance of notice under section 148 of the Act in terms of third proviso to section 149 of the Act. Now, paragraph 14. In any event, as the impugned order under section 148D of the Act has been passed on 4/4/2022, that is, after receipt of the detailed reply by the petitioner dated 31/3/2022, the assessing officer should have considered the same as it was available on record. By not considering the reply of the petitioner dated 31/6/2022, the mandate of section 148AC has been violated, as it casts a duty on the assessing officer by using the expression shall to consider the reply of the petitioner assessee in response to notice under section 148AB before making an order under section 148AD of the Act. Then last paragraph 15, sorry. In fact, this court in FENA Private versus ACIT had quashed the order passed under section 148D of the Act in similar circumstances where assessing officer had not taken into consideration the replies along with the documents or evidences filed by the assessee before passing the order under section 148D. 16. This court is of the opinion that significance of issuance of a so-called notice at a stage prior to issuance of a reassessment notice under section 148 of the Act has been lost on the respondents. This court has taken judicial notice that in the majority of reassessment cases post 1/4/2021, the orders under section 148D of the Act use a template of the general reason to reject the defense of the assessee on merits, namely found devoid of any merit because the assessee company has failed to produce the relevant in respect of transactions mentioned in so-called. It is established that the assessee has no proper explanation. Consequently, this court opinion that
So
a progressive.
They sent it back.
Yes, minus. Sent it back, yes. Not quashed or only sent it. Now, one more judgment I am bringing to Lordship's attention is, my lords, Calcutta High Court judgment.
Right.
That is in the case of RN Fashion versus Union of India.
Right.
In this case, before I take your Lordship's attention to the relevant paragraph, my lords, the fact is like this. On one undated notice, so-called notice was issued under 140AB was not bearing any date, my lords.
Yes.
No. And the date for filing the reply was fixed to 18/3/2022, my lord.
Correct.
But 18/3/2022 fell on a public holiday.
Right.
Because that followed by two other successive days, which is followed by Saturday and Sunday, which are also holiday for the department.
And then they filed it on Monday.
Exactly. Filed it on Monday.
So
On
that
20
was not considered. So
not considered at all. So directed.
All right. So it was again sent back.
Sent back, my lords. Then one more judgment, my lords.
Shillong.
That is in the case, yes, Shillong, Honorable Shillong High Court.
Right.
Meghalaya High Court.
Correct.
Your Lordship may kindly see. Paragraph 3. Paragraph 3.
All right.
The petitioner responded so-called notice and a copy of the e-proceeding response acknowledgement dated 33/2022 has been appended to the petition. it is apparent that the petitioner replied to the initial so-called
This is too straightforward.
Sorry?
Because this is too straightforward because the penultimate paragraph, the order said no reply had been filed. When in fact the reply was filed on 31st.
Reply is filed, my lord. Not your place, my lord. In this case, the order says no reply has been filed.
Correct.
But in my case, reply has been filed. It's on record at the time when order was passed. My lord, next, my lords. Then before other judgments are there, when I will proceed to argue for lordship on oral hearing. There are so many judgments, but the importance of opportunity of being heard, the significance, all that.
No. In your case, in para 4, they've been careful to say in response to the said notice, just come to page 23.
Page 23, my lord.
Your paper book. Para 4, last line.
Yes, my lord. Based on the above information. Last line. In response to said notice, neither in reply nor any documentary evidence has been submitted as within 2 years.
Within the stipulated time. So he's careful. See, it's not that he's not aware of what he's saying. He's not saying I've not received any reply. He says I've not received it within the stipulated time.
My humble submission for lordship is your lordship has to read this along with annexure 2 minutes.
Yes.
Which is a document generated in the department.
No. But that has not been allowed, sir. It was a time petition without specifying how much time you want. Let's assume you asked for 7 days. Whether you ask for 7, 10, whatever, it's not been allowed.
Yes, sir.
When it is not allowed, presume it is.
My lord. Now on this, I have annexed 2 judgments. I will take your lordship's attention to that. My lords. First, your lordship, I kindly see judgment in the case of pillars. My compilation, which I have given to your lordship, pillars, page 22. Sorry. This is S.K. Gupta and another versus Commission of Sales Tax, New Delhi. It starts from page 72, lords. Page 72. Those. Only one paragraph at page 74, lords. During the course of hearing, my lords, during the course of hearing, the Lord and Counsel for the petitioner brought to a notice copy of the application dated 2nd May 1980, by which the petitioner sought adjournment from the sales tax officer. He also brought to a notice the postal receipt by which it stood proof that this application was dispatched by registered AD post to sales tax officer. Word to so and so. It stands proved on the record that the said communication did so and so to deliver to the agency, namely this STO on 3rd May 1980. If the office of the sales tax concerned was not properly organized and he missed his application, when he took up the matter on 5/5/80, the petitioner cannot be blamed. It is correct that the party had no absolute right to get an adjournment. The party, however, did have a right to have his application considered. It was not considered. Indeed, the sales tax officer proceeded to record differently in his order so and so, which you have extracted above. That's a clear non-application of mind and casual approach to the assessment. It's surprising that even the appellate and revisional authority did not examine this aspect. In view of this matter, we are persuaded to hold that the petitioner has been assessed expertly without an adequate opportunity of being heard, being granted to it. The improved order of assessment, appellate order, revisional order, therefore quashed. So that is my humble submission. Because I may not have a right to claim for adjournment, but I have to subscribe that my application be considered on its own merit. That is my humble submission. Next, one more judgment of Steel Authority of India, Honorable Apex Court, my lords. It starts from page 64, my lord. Only para 8 I will be placing, page 64.
Yes.
It starts from a relevant page, my lord, page 70.
This is this court, Orissa High Court.
Yes, arising from our High Court.
No. It is a what you put at page 64 is the Orissa High Court judge.
Yes, sorry. Our High Court.
Correct.
Yes, paragraph 8. It is not disputed that the declaration forms which relate to tax demand at about so and so crores have been produced before the first authority at the time of consideration of stay application. According to an counsel for the opposite parties, here production is not sufficient after relief and appeal. He has referred the conclusion of the commissioner and has also indicated several dates as to show that 8 adjournments are granted petitioner. Because the number of adjournments is not always sufficient to conclude that due and proper opportunity was granted. grant of earlier adjournment cannot be ground to refuse prayer for a subsequent adjournment because
You have the Punjab and Haryana High Court judgment in Anshul Jail?
minors. Sorry?
Punjab and Haryana judgment in Anshul Jail.
Yes.
Where is that?
That's not there. It's not there in Delhi High Court. They have not taken into consideration.
Yes, do my lords have copies, lords? I'm sorry.
Anshul Jain, Punjab and Haryana.
Punjab, Haryana, yes.
No, we don't have.
Oh.
I have a copy.
दोनों आनीपारे तमें पान खाओ सांग
Lakshmi may kindly see. Lakshmi may kindly see. I have copy.
I can share one.
one more.
One more, yes. Now, this is very much, Your Lordship, it appears that it is making a blockade. Now, my lords may kindly see in that judgment. Mr. Sao may permit me for 5 minutes. I'll just explain what was the ratio in that case.
Yes.
And what the facts involved in that case came to decide that whether the writ court can interfere an order passed under section 148 capital A small d, whether there is an erroneous exercise of jurisdiction vested in it or is without jurisdiction. That is, Lord, in that case, Lordship will see in that Anshul Jain case, an assessment for the assessment of 1819 was splitted. Then a notice under section 148A(b) was issued. Okay, alerts. Then that objection was not considered as the allegation of the petitioner goes on, and an order under section 148A small d was passed. And the Honorable High Court of Punjab and Haryana writ petition was filed for quashing of the same. Therefore, the question was, Lordship will kindly see the page 2, what they formulated question, whether at the stage of a notice under section 148, writ court should venture into the merits of the controversy when AO is yet to frame assessment, reassessment in discharge of statutory duty casted upon him. Section 147 of the IT Act. It goes undisputed. Now the Honorable High Court, I'll just take 2 minutes more. Thereafter, I know my lords.
No. Please take.
What is the most important paragraph? Lords, you will kindly see at page 5.
Correct. Thus, the consistent view.
Thus, the consistent view is that where the proceedings had not been concluded by the statutory authority, the writ court should not interfere at premature stage, full stop. Moreover, it is not a case where from bare reading of notice, it can be axiomatically held that the authority has clutched upon. Lordship, you may kindly see these very key words. This is the catch. Has clutched upon the jurisdiction not vested in it. My lords, this was not the case that the assessing officer has clutched upon the jurisdiction which the assessing officer did not have. The jurisdiction point, my lords, lies in section 149(1), which yesterday I have brought to your lordship's kind notice that the period was reduced from 6 years to 3 years, and with a condition that the assessing officer must have in his possession of the books of accounts or evidence, or that the escaped income is in the form of an asset. This is the main provision, my lords. This was never the case of the petitioner in Anshul Jain's case. What they said in this case, my lords, that my objection has not been considered. So therefore, the order passed under section 148(1)(d) has been passed by not considering, and therefore it goes for quashing balance. The Honorable High Court of Punjab and Haryana said this is maybe a erroneous exercise of jurisdiction vested on a statutory authority. It is not a case where a quasi-judicial officer has acted without authority of law. Without authority of law which has not been vested. Now, this view differs from the cases which I have got. And therefore, my lords, I brought to the notice of this Honorable Court the legislative history of this 147 and 148, how this law has a growth. In 1922, it was there in the form of section 34. There was no provision of making any notice, issuing any notice. Then gradually it went on in 1957, 34(1)(a), 34(1)(b) was there. Sorry. Then, my lords, it went on 61. Again, there was amendment. Again, with effect from 1/4/89, there was an amendment and a case was filed. Lordship is already aware of that Eliminator India Limited case, where the Honorable Apex Court said, in spite of the amendment, the change of opinion is a self-built defense. Eliminator India case, may I submit? Or I think 328 I know. But the page, and now it is 410.
No, but with your arguments at 410 also, we don't feel tired.
Bigger part?
With your 410 also, we don't feel tired.
Many, I am thankful to your Lordship. I am privileged. I am to argue before Lordship a judge who has a reciprocative and a good reception, having interaction with the bar,
right,
is a court which is enjoyable,
right,
and particularly before a judge.
No, that's all right. Now, all you put a break on.
No, I am stopping here. I cannot go beyond.
All right.
So, my lords, so the very purport of the amendment was both for the benefit of the assessee, number one. Number two is for the benefit of the revenue. You cannot go on sitting without reopening the assessment years together. So that is a stop here. And the benefit to the assessee was that the arbitrariness of the assessing officer is checked. He must, in his possession of books of accounts, evidence, as has been mentioned, must have reason to believe that the income escaped assessment is in the form of the asset. Nowhere the assessing officer writes that it has escaped in the shape of an asset which exceeds so and so amount.
No, but at the stage of 148A,
correct.
The satisfaction.
I'm coming to this.
Yeah, no. I'm saying by its very nature, the kind of satisfaction for 148 has to be different from the satisfaction for 148A.
Yes.
If both are the same proceedings, there's no need for 148 at all.
148 notice before it is issued. The legislature fit in its intention to bring the procedure and the procedure is mandatory. Okay, my lords, I think I am correct. If I am wrong, my lords.
No, the word shall. You'll emphasize the word shall.
Shall. Shall is mandatory.
Mr. Sahu says that shall is for the revenue, but shall is not. Mr. Sahu, he adds a caveat to your submission. He says shall is only for revenue, not for the SSC.
Both of them. Both of them.
No.
A SSC has got also a duty cast upon him to give his reply.
No, but Mr. Sahu says, so what if he's given a reply late? It still has to be considered.
I don't have the audacity to make any comment on him.
No, it's important. I'm putting this to you because we have to interpret.
Yes.
We have to interpret the word shall.
Yes. Now, my lords will agree, definitely will agree, that the law which has been brought into force with effect from 1401 is quite discernible and recognized.
No, I'm just logically taking this argument.
Yeah.
Suppose under 148A, after considering all your submissions,
yes,
following the letter to the T, he still thinks notice should be issued under 148.
Yeah.
Can the revenue not sit back and said, I've done this entire exercise, I'm just going to copy paste the 148A order and issue it as a 148 order?
I'm not.
Then you will say, no, this is not mine.
No, my lords. I'm correcting myself. Perhaps I'm not communicated properly. I'm not understood properly. I am saying, my lords, before you invoke this power to issue notice under section 148, you have to satisfy the limitation. And thereafter, because the very purpose, Lordship knows, I have also brought the book of interpretation of statute by G.P. Singh. My lords, nothing can be added, nothing can be subtracted. Okay, my lords? Now, my lords, every section of a statute has got its meaning.
No, just this one line.
Yeah.
If the petitioner has any grievance on merits thereafter,
yes,
the same has to be agitated before the assessing officer.
Why? Why before the assessing officer I should be sent back?
No.
Why have you invoked this power under section 148A?
No, these are questions to ask the Supreme Court.
My lords, what the Supreme Court, definitely, I welcome the judgment of the Supreme Court. I definitely. But your lordship will kindly see. The Supreme Court never said that bring that, make the provision under section 149 totally obtuse, redundant, and invoke. Go on invoking. No,
it's like a screening. It's giving you a chance to convince the revenue, listen, drop the...
Yes.
Right? If you fail in convincing the revenue, you have one more chance to convince the revenue at the assessment proceedings.
Correct. I have no dispute over that.
That's a simple logic of this whole amendment.
Yes. That is that.
So the Supreme Court is saying, why unnecessarily drag the High Court into this?
The constitutional courts are already working with
exactly
many.
So Supreme Court says, please leave the High Court alone.
Question is, my lords,
yes,
the writ court is now a writ of statutory proceeding.
Right.
Okay, my lords.
Yes.
Whether it has acted in excess of jurisdiction,
correct,
or without jurisdiction,
correct,
or that is an error on the face of record.
Correct.
These three things have to be satisfied before a writ of certiorari is issued.
Correct.
Now, my lords, the very purpose...
No. So, just to do on the jurisdiction point, I think what the Punjab Haryana High Court is saying is this.
Correct.
One is to have jurisdiction and not exercise it.
Yes.
So, that's all the Punjab... So, Punjab Haryana High Court is not saying we do not have the jurisdiction.
Yes.
It says we may have the jurisdiction, but we are not inclined to exercise it.
Erroneous. There they say...
They are not persuaded to exercise it in this case.
They made a distinction. I'm sorry, my lords. That a quasi-judicial authority may have exercised the jurisdiction erroneously. But this writ court is not meant to correct it. That's all.
On merits.
On merit. I am not on merit. I am not at all merit.
You're on procedure.
Because 148 notice, after the 148 notice is given, the assessee has to file a return as specified in the notice. So and so date. Thereafter, the assess proceeding starts after filing of the return. Then 143, 2 notice is given. 142, 1 notice is given. Likewise, questionnaire is given. So this process itself is a rigorous process. And it may end 1 year or maybe, I think 153 is the limitation, 21 months. 21 months we have to conclude it. The legislature, being conscious of this fact, has brought this 149(1) to curb the unnecessary use of this power. As otherwise, why, my lords, this could have been done in 142022. What was, like, my lords, this is the mischief they found. And the Haddon's rule says the law, when it was there at the time of the amendment, and what was the purpose. So, my lords, my respectful submission, now it is 4:15, my lords. So, my lords, Baljatra is still not over. And Mr. Chimaka is regularly cheating us, my lords.
I see. He's promised to take you to the Bali Jatra.
He will not spend a single copper. He doesn't spend a copper. So, my lords, may I continue tomorrow, my lords?
All right.
Or any date?
Let me finish, I will start. I am yet to finish. But one thing, before your Lordship continue proceeding, Lords, 2 things your Lordship have to keep in mind.
Yes.
One is 148A, as your Lordship said, it can be agitated in 148 proceeding. This 148A...
Just the keeping your powder dry. When I asked you that question, do you want to exhaust all these points here or you want to wait for 148? That's what I meant. See, it's up to the SSC ultimately where they want to agitate these points at this or later stage. So that is something that you take a call on.
Because 148A order is not an appealable order under section 246.
No, correct. Which is 226.
Unlike reassessment.
So you can take it. Even the Punjab and Haryana will not say, and Supreme Court will not say that no High Court should ever deal with any such petition. Because High Courts always have a jurisdiction.
Correct.
That's part of the basic structure, 226. You can always go to the High Court.
Correct.
And if there are egregious violations of the law, you can't say that no jurisdiction lies in the High Court. So it's only whether the High Court should, at this stage, exercise its jurisdiction or not.
Kalida next Wednesday. Sorry. Yes, will by tomorrow or next Wednesday.
Why?
As your Lordship pleases, because I don't have anything.
No, I think tomorrow, because afternoons we are usually done.
Tomorrow at 2 p.m. Milord starts 2 p.m.
2 p.m.
Milord, Delhi High Court also passed Milord the judgment in same issues, Milord.
Sorry?
Delhi High Court also passed in same issues, Milord.
Very good.
Right.
In favor of the revenue. Would be, Milord, there are interim orders in all these cases, Milord.
Yeah, they're all continued.
And barring one, Milord, that is WPC.
But it will be interesting to see if we don't, and by 2 p.m. tomorrow if they do something.
Bereft of what my learned seniors have addressed, Milord, Lordship may just keep in mind that this entire procedure is under the supervision of a specified authority, who is no less than the Commissioner or the Chief Commissioner. My humble contention, Milord, is that the assessing authority under 148 is definitely way down in the hierarchy, Milord. And if a particular aspect found out by the officers under 148A has been approved by a higher authority, may be institutional bias. I may be wrong, but
at the stage of 148,
148, Milord, is a stage, Milord, which is over after 148A has been approved. 148A, 148AD, Milord, it's with the approval of the higher authorities.
Right.
And once this is approved by the higher authorities, your Lordship may see the limitations imposed on the 148 proceeding. And
but it's like saying, let's say 263, the CIT says this has to be reopened and sends it back to the AO. It's not necessary that the AO should enhance the demand or...
that is a specific, there is a specific observation. They'll act as such.
Yeah,
but here what has happened is getting the seal of... I'll continue tomorrow after court.
Item 84.